Good morning. This is the Cannabis Compliance Board meeting set for May 23rd, 2023 for 9 a.m. This is Chair Douglas for the record. If we can deal with our first order of business, which is call of the roll.
Great. We have Member Merritt,
I'm here.
Member Durrett,
Here.
Dr. Young. Here. Member Guzman Freilich.
Here.
And Chair Douglas.
Here. All of the board members are present and accounted for this morning. That takes us to public comment. This morning, we received a few items via email that we've taken notice of and been handed to the members this morning. But anyone in Las Vegas who wishes to make a public comment, if they please come forward, make sure that you state your name first and then let us know what you have to say, please.
Thank you and good morning. My name is Rachel Lee and my company is Sunflower Compassionate Company. I know I have 2 minutes, so I wasn't expecting to go up this fast, but see if I can find it. And if I can't find it shortly, then I'll sit and come back up. Found it. Thank you. Okay, good morning to everyone in the building and to the entire Cannabis Compliance Board, directors and members. Today, I wish I had a few extra minutes for my public comments. So if anyone in here would like to be so kind to donate your minutes to me, I would really appreciate it by you standing next to me and briefly stating so. I would only request one or maybe two other people, and this would at least give me 6 minutes to sum up my comment. To the Cannabis Compliance Board investigators, thank you for your hard work and dedication to safety and safe practices of the cannabis use, sales, and consumption. I recently resigned in April from a cultivation facility after receiving public health and safety bulletin from the Cannabis Compliance Board via email. This email stated that this cannabis cultivation company used an unapproved pesticide called ethafen. I encourage anyone, including the cannabis cultivators, to research exactly the harm and studies that these pesticides could do to the body immediately and in time. During my short 8 days of employment, I began to notice and experience some of the side effects described by this pesticide. I also wanted to quickly talk about the bigger picture of the title of social equity and speak to people who have worked tirelessly to start this entire process. I heard two disturbing things while watching workshops of a great mentor of mine and coach. She believed she failed. I wanted to say, Aisha, you did not fail. You struck a match that no one else was attempting to strike. So thank you. Also, I heard a bitter student at one point, a student of CEIC state that Mr. Cannabis was doing something corruptive in the board with his friends and social equity. I wanted to tell this accuser, Eli, I do not know Mr. Cannabis nor his friends. I don't know that man. And I did not know Aisha before going to the school CEIC. I do know that at one point you attempted to ask me if you could pay my application fee in return of 49% ownership. And I respectively declined that. So stop coming to the podium as if you were given a bad hand or deal because you had the same opportunity as me. Also, I wanted to talk about the true definition of an asset and what is the required definition as an asset to satisfy the $200,000 in liquid assets. Would equity be in a home, a boat, or car? What is the assets one is worth? Can I continue on? Did I get anybody extra time?
We are going to try to keep our
I can
time
continue?
short today so we can get through the public comment.
I can continue on. Thank you, sir.
Just very quickly, please.
Just another couple of short lines. I appreciate it. The difficulties of finding a location due to commercial realtors and the owners who wish to or could not lease to a cannabis establishment for one reason or the other, being that maybe they owe the bank or they just don't want to deal with this type of establishment whatsoever. And this obstacle, I see in this is an obstacle in the way of social equity applicants and people who do not have the capital to pay. This can cause a social equity applicant to not be successful. In the beginning of approval of cannabis establishments, in the beginning, and I believe it's 2014, an applicant first had to find a location, and then they were able to move forward. So today I'm requesting the opportunity for the consumption lounges, not just social equity, but the consumption lounges to be able to first find a location. Then after such location is found, the applicant would be committed to that approved jurisdiction. Another comment that I would like to say, just as New York does, the state allows social equity applicants to at least to be able to receive some sort of funds and in time pay those funds back. I am asking if the board would be willing to do something similar to what New York is doing. Also, this could be paid by some of the shenanigans that you guys have to face when people are coming in on fines from unapproved pesticides and hiding cannabis in the ceilings. To the people who have helped me, like Ken Landrum, Doug Turner, CEIC, and the entire community, and sent encouraging words like Mr. Peckman, thank you. And to the others whose names I won't mention, but you know who you are. Thank you. Also to the cannabis establishments who do not wish to assist social equity applicants. Just 2 days ago, remember that over 500,000 people were here attending EDC. I hope you are not afraid of some competition from little old social equity applicant. If your cannabis lounge was open at the time, you wouldn't have been able to host a percentage of these people alone. So we need these lounges. Stop being greedy. I am requesting to create a petition to change the jurisdiction, and that once we find our locations, that we're able to be locked into that location. The distance requirement pretty much states that a church, a school, or a public place could be closer to a cannabis establishment than a casino. So if the school was 1,000 square feet, they're saying that the casino has to be 1,500 square feet away. I was wondering if that sounds strange to anyone else. In summary, I am looking for investors and I can be reached via email at rachelshelleylee@gmail.com. Is it okay to put my phone number? And phone number, area code 702-955-0078. Thank you for letting me say my entire public comment, and thank you for your time.
Other public comment in Las Vegas?
Hi, good morning, and thank you for the opportunity to speak today. For the record, my name is Abigail Kaufman, ABIGAIL KAUFMANN, and I am the Secretary for the Board of Directors of the Chamber of Cannabis. I'm here today to follow up on the outcome of Executive Order 2023-003, which required agencies across the state of Nevada to review existing regulations. After Governor Lombardo issued this executive order, 13 members of the Chamber of Cannabis presented the CCB with regulations and related statutes that we feel are unnecessarily onerous or poorly executed. I applaud the CCB for following through with the April workshop to solicit input from industry stakeholders pursuant to the order. And I'm pleased to see that the NCA's proposed repeal of NCCR 15.055 is being heard next month. The executive order stated that each department must provide the governor's office with a report containing a ranked list of not less than 10 regulations for removal by May 1st, 2023. The order also stated that it is in the best interest of the state that its regulatory environment be concise, transparent, stable, balanced, predictable, and thoughtfully constructed. In the name of transparency and in the best interest of our industry, I'd like to request that the CCB publicly post the list of regulations that were submitted to the governor's office. The materials provided ahead of the April workshop listed 5 proposed NCCRs for repeal. 2 of these 5 were simply repealing NCCRs that were definitions. I've not located any other CCB materials related to the executive order since then, but I suppose it's possible they're out there. Per the executive order, state regulation should protect workers, consumers, and the environment while promoting entrepreneurship and economic growth. All of these are incredibly important to the stakeholders of Nevada's cannabis industry. And in my opinion, we deserve to know regulations our regulators are repealing in an effort to accomplish this. I've submitted my comment and contact information in advance of the meeting if you have any questions or want to follow up. So thank you for your time.
Thank you. Anyone else with public comment Las Vegas?
Good morning, CCB board members and Executive Director Cannabis. I'm Bob Kuroko, CEO of Silver Lion Farms. After nearly 2 years of working with the CCB and this board, I am pleased that you're finally moving forward to open a medical cannabis cultivation and production licensing round in rural White Pine County. Something that's been required by law is defined by NRS 678B.220 and something that White Pine County has been anxious to get going. However, as I stated multiple times in public testimony and in private, I continue to be concerned that this board is changing regulations to award a one cultivation license via a new random number generator, the lottery concept, as opposed to issuance on merit. The purpose of the shall language in NRS 678B.220 regarding the issuance of one license for a rural county was intended to give a rural county the opportunity for economic development and economic diversification. With only one license to be awarded by the state, it is critical that White Pine County be given the best opportunity to do what the law had intended. Furthermore, using a random number generator, the lottery, a rural county like White Pine County runs the risk of the state awarding the license to a party who meets the minimum state requirements, but falls far short of achieving the optimal outcome of material economic development for the county. Or worst case, the state may award the loan license to a licensed squatter who simply sits on the license without putting the license into action. There are numerous precedents for license squatting in the state of Nevada and even in White Pine County. Inexplicably, the state issued a retail cannabis license in White Pine County to a Clark County group in 2018, and this board continues to grant extensions year after year for them to continue to squat on the license, sit on the license, with the latest extension authorized by this board in March 2003. Even more troubling, the state issued the retail cannabis license to these same individuals, even though at the time of issuance, White Pine County had an ordinance against retail cannabis. How does this happen? And even more egregious, the state issued retail cannabis licenses to these same individuals, TRNV LLC, in multiple other rural Nevada counties, in addition to White Pine County, including Pershing, Lander, Humboldt, Mineral, Story, and White Pine, Lander, and Pershing counties had active moratoriums against cannabis at the time. Lander and Pershing counties still do. TRNV LLC continues to squat on these licenses with the full permission from this CCB to this day, deliberately or unintentionally. The White Pine County lifted its moratorium in October of 2021, the time that it started to seek its medical cannabis license per NRS 678B.220. The point here beyond the seeming past corruption, this board continues to perpetuate the original sin by allowing the license squatting that has been going on since 2018. Should the random number generator award the loan cultivation and production licenses in White Pine County to the same group or another that strategically squats on the license just to block the competition in White Pine County, White Pine County will not be permitted the ability for economic diversification, as was the intention of the law, NRS 670B.220. Given the history and the fact that White Pine County originally petitioned this board back in February 2022 for its rightful licenses, I submit that this matter must be resolved under the previous law, and this board should not impose a new regulation, namely the random number generator, the lottery, that further hurts White Pine County. It is imperative that this board award the medical cultivation and production licenses based on merit so that this matter is resolved fairly and in the best interest of the long disenfranchised county. Rural counties like White Pine, especially given the fact that they are only issued one license per type, licenses should be awarded based on merit not the lottery. Lastly, these cultivation and production licenses are especially important to White Pine County. As you may be aware, White Pine County has had one main large employer, the gold mine. In 2005, the mine struggled and the county went into receivership, custody of the Department of Taxation of the state of Nevada. This could certainly happen again, and White Pine County is counting on the cannabis licenses to play an important role in diversifying its economy with the aim of increased economic stability. They need the best business partner they can get to fully realize this aim. In summary, the licenses should be granted under the existing law when the state licenses were formally requested by White Pine County, namely February 2022. The CCB's new requirement, the lottery, makes absolutely no sense for White Pine County or any other rural county. It is in the interest of these rural counties that the license is issued to meet the most capable company that fulfills on the economic development for the county. With the random number generator, the lottery, selecting the lone license recipient, it gives bad actors the incentive to apply as a means of strategic squatting on the license, thus blocking competition. As noted in my comments, this is not only a possibility, it is likely, especially given that there is an active squatter blocking other businesses in White Pine County right now and has been since 2018. And this squatter,
Sir, at this point, you're over the time, and you're also misrepresenting us the squad issue in terms of who did what. So you had wound up, we have your written material. If you have one closing thing you want to give us,
I have
that
just
to
another
us,
30 seconds.
and then
I would ask, Chairman, that you indulge me. We're not
I don't
following
wish
the,
to at this point, because I presume you're going to comment again when the item comes up as to whether or not we should adopt the ordinance. So you're repeating yourself at this point. I don't know if we have other people, but we do have a full agenda today to get through.
I'd like 15 seconds.
Go ahead, go ahead.
I'm asking this board today to open the required licensing round in White Pine County per the shall language without a new regulation to issue the license by random number generator to a random entity that just meets the minimum state requirements, and potentially to an entity that has absolutely no residential interest in White Pine County. White Pine County is looking forward to receiving these licenses. The licenses, this issue is very important, and it must be a business who is truly committed to the county, a business committed to fulfilling on the original intent of the law. Thank you.
Other public comment in Las Vegas.
Hi,
Good morning.
my name is Armand Bennett. I don't work with any establishment. I'm not with any business. I'm just here to give out some knowledge maybe useful for you guys. May come off a little strange. I've done a little bit of research, and there's actually some seed cultivators that are actually located in this state. I've already given this information out to narcotics. I've already given this information out to law enforcement. And I'm just thinking maybe you guys will find some fascination, or maybe it's maybe useful for you. The first one is called Technical Cultivators. They're a seed developer that's located in the state. Another one's called Sin City Seeds. They're also located in the state. We all know with licenses that a lot of times with licenses, that's what gives people the legality to cultivate cannabis. There's a lot of websites on the internet that sell cannabis seeds. Through my research, cannabis seeds are legal to buy for souvenir purposes. What somebody does with the seeds is their discretion and against the law. Going into more research and more discovery, I've also found out that people are actually taking it one step higher. Instead of selling seeds, or selling clones, which is basically they take a plant, they cut the branch off, they dip it in a rooting hormone, and they put that branch into the soil just like a seed, and it's genetically the same as the plant that they cut it from originally. There's a website. It's called Strainly, STRAINLY. They sell clones on that website. Some of those clones on that website literally go for thousands of dollars. I'm not sure how people are able to buy those. I'm not sure how the people, if that website is actually asking for people's credentials, to make sure that they're actually having licenses before that they're buying them. And I don't know why somebody would actually buy that to be just to be technically true, because if you're selling a clone, in my mind, I'm thinking that thing's going to die in the process of it coming through the post office. Just some information. I don't have really too much more to say. Like I said, Strainly is the site that sells clones, and Sin City Seeds and Technical Cultivators are seed cultivators that are in the state. That's all I have to say. Have a good day.
Thank you, sir. We have another person.
Good morning. Oh, I've had my coffee. Pardon. Good morning, members of the board. My name is Bri Padilla. For the record, I'm the executive director of the Chamber of Cannabis. And I'm coming here today just to express my sincerest hope that the board hear and respond to the struggles and the concerns voiced by our industry, especially as it relates to the governor's request that certain regulations be rolled back. We hope and applaud the CCB for recognizing the need to adapt and evolve with the change in cannabis regulations. However, we can't forget that while our state has celebrated the revenues our industry brings, our journey is far from over. In these trying times, our industry is witnessing businesses shuttering and hardworking individuals losing their jobs. Unlike any other markets, which I've had the opportunity to visit, we are really fortunate to have mechanisms and means to engage in constructive dialogue with our regulators. It is in the spirit of collaboration that I implore the CCB to continue supporting our operators with additional rollback measures and mechanisms to bring concerns to your attention without fear of reprisal, which is again not anything that the CCB has advocated for, but I just want to represent our industry and the concerns that have been voiced to me. We are all united in our mission to build a better cannabis industry, and I do want to take this opportunity to remind us all that we're all on the same side. We're all here to bring medicine and plants to people who need them, and we're also here to positively impact and build up our community through this incredible economic economy. So with that in mind, together we can overcome the challenges that lie before us. Together we can build a better, sustainable, and bigger cannabis industry. And I look forward to continuing to do that with you. Thanks.
Thank you. Anyone else in Las Vegas wish to make a public statement? Good morning.
Morning, ladies and gentlemen. My name is Sean Zamite. I'm representative of Encore Labs, a leading ISO certified lab testing company in California and Arizona. I urge the Nevada Cannabis Compliance Board to open the licensing window for cannabis lab testing. By exercising the existing provision in the code allowing for a 10-day application window, we can foster growth, innovation, and consumer safety within the Nevada cannabis industry. Opening the licensing window will drive competition, ensuring rigorous standards, accurate labeling, and increased consumer trust. It'll also expand testing capacity for faster turnaround times and enhance product safety. Welcoming new lab testing companies will bring fresh expertise and technological advancements, propelling Nevada's cannabis industry to the forefront of innovation. Furthermore, opening the licensing window will stimulate economic growth and create job opportunities for local residents. I urge the Nevada Cannabis Compliance Board to seize the opportunity and open the licensing window for future cannabis lab testing. Thank you for your consideration.
Thank you. Anyone else in Las Vegas wish to make a public statement this morning? Hearing none, we move to Carson City. Do we have anyone in Carson City this morning? Or Reno, whichever it is.
Hello. Will Adler, representing the Sierra Cannabis Coalition. I wanted to use this public comment for a true public comment, something that's not on this agenda, but just a point to bring up. Speaking with the governor's staff and their legal counsel, they advised me that the petition previously filed by the Sierra Cannabis Coalition, October 28th, 2022, and then published in November 8th, 2022, and then heard November 15th, 2022, is still a valid petition and did have merit. They said that it is on the CCB to bring forward such an issue, to have that greater workshop or have a discussion about what is the best practices across the country when it comes to lab testing standards. It is on you guys to bring that forward if you wish to have that workshop. We did state we would have it February or March this year. We could have it later this summer and still have a pretty good effect. If the CCB doesn't wish to bring it forward, I could bring forward a second petition with a more focused and narrow view if that is acceptable. But just wanted to bring that forward and say, we still like to have that discussion or have that develop discussion about, what has changed nationally, what could be the best practices, and what could Nevada be doing as well. Thank you very much. Good day.
Thank you. Do we have anyone else up north who wishes to make public comment? Hearing none, I understand that we have a mechanism for public comment, other public comment.
Yes, so Sarah, is there anybody on Zoom who's wishing to provide public comment today?
For those on Zoom wishing to give public comment, please click the raise hand icon. If joining by phone, dial *9 to raise your hand. I see no public comment.
That would then end public comment. We've had public comment in Las Vegas and Northern Nevada, and it was available online this morning, and no one took advantage of that opportunity. That would move us to item number 2, minute meetings. We have item A, consideration for approval of the April 14th, 2023 Cannabis Compliance Board Workshop minutes for possible action. And additionally, we have item B, consideration for approval of the April 25th, 2023 Cannabis Compliance Board meeting minutes for possible action. They can either be taken together or separately, depending on the preference of the board.
Member Durrett, for the record, I move to approve the meeting minutes under agenda items 2A and 2B.
We have a motion for approval of A and B. Do we have a second as to that motion?
Member Merritt, I will second.
We have a motion. We now have a second. Do we have any additional discussion or any corrections of either one of those minutes for the record? Hearing none, then the vote. All in favor of approval of the minutes as so stated from April 14th and April 25th, the items A and B, please say aye.
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 Any nays? Any abstentions? Motion carries unanimously as to the acceptance of the meeting minutes. That moves us to item 3, request for transfers of interest. Item A, Dune Operating Holding LLC is our first matter.
Good morning, Chair Douglas, members of the board. For the record, I am David Staley, Chief of Investigations for the CCB. I'm here to present agenda item 3, which consists of 3 transfer of interest or TOI applications. Item A is an addendum to TOI 22000001 by Dune Operating Holdings LLC. TOI 20001 was heard at the January 2023 board meeting, January of 2023 board meeting, and the board approved Dune's request to acquire cultivation licenses C175 and RC175 from My Life Organics Inc. Dune did not request a waiver of NCCR 5110 at that time related to the need for owners of less than 5% to acquire agent cards. In this addendum, Dune is requesting a waiver of NCCR 5110 pursuant to 5.125. If approved, the agent card requirements for owners of less than 5% will be waived. Dune has adequately addressed the items required in NCCR 5.125 to allow the board to approve such waiver. Staff suggests that if approved, the board limit Dune's waivers to expire on its next TOI agenda date. No areas of concern were identified during this investigation into the NCCR 5.110 waiver. I'm available for any questions, and my understanding is that Connor D. and General Jeremy Holmes are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Thank you. Before I open it up to the board, identify yourself and any statement you wish to make.
Morning, members of the board and Director Cannabis. My name is Jeremy Holmes, and I represent Operating Holdings here. I think what Mr. Staley said was pretty accurate. There was a change in council TOI process, and I think the waivers kind of fell through the cracks. The people that are being applied for here, they're passive, silent investors. They don't have any ownership, or they don't have any control over the business operations, any managerial functions, anything that goes into the actual business side of cultivating the cannabis here. So we believe the waiver is appropriate. And as Mr. Staley said, and Mr. Yee is the manager of Operating Holdings is here. If you have any questions for him.
Thank you. Board members, any questions? If we have no questions of the licensee or from our staff, can we have a motion that would comport with what was requested as the waiver?
Member Durrett, I move to approve the matter requested under agenda item 3A relating to Dune Operating Holdings. The board would be approving the waiver of NCCR 5.110 pursuant to NCCR 5.125, and that would be set to expire on the next TOI agenda date.
With that motion.
Member
do
Freilich,
we-
second.
Thank you. Motion for second from Member Freilich. And I know we have someone else on our screen, if they could identify themselves, just for the record.
Yep. Hi, my name is Connor Yee. I'm a manager of Dune Operating Holdings.
Thank you. We have a motion. We have a second. We have any additional discussion, questions? Hearing none, all in favor, please say aye.
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 Any nays, any abstention? Matter carries. Thank you very much.
Thank you. Have a good one.
Thank you.
That moves us to item B, JDW Nevada LLC.
Good morning, Chair, members of the board. For the record, my name is David Staley, Chief of Investigations. Item B is a TOI application by JDW Nevada LLC. JDW holds 2 conditional and non-operational cultivation and production licenses in Clark County, Nevada. TOIs 230006 through 230009 were filed to transfer 84.85% of JDW membership to Kathleen Watson after the death of her husband, Jeremy Watson, and for the transfer of 15.5% membership to Robert Brams through his company, Harmony Nevada LLC. JDW has also requested waivers of NCCR 5.110 pursuant to NCCR 5.112 and 5.125. If approved, the requirements for prior board approval of transfers of less than 5% of JDW ownership and agent card requirements for owners of less than 5% will be waived. JDW has adequately addressed the items required in NCCR 5.112 and 5.125 to allow the board to approve such waivers. Staff suggests that if approved, the board limit JDW's 5.112 and 5.125 waivers to expire on its next TOI agenda date. Areas of interest were identified as TOI because JDW does not have a current Clark County business license, and due to questions regarding the nature of Tampa Bay Investment Partners LLC manager position of JDW as a limited liability company. I am available for any questions, and my understanding is that Taryn Reed, Kathleen Watson, Robert Brahms, and Daniel Friedman are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
Noting for the record, before we get to our licensee, this is a non-operational entity at this time, if that's my understanding. And part of the transfer is based upon the death of the late husband.
Yes, sir, that's correct.
And part of the reason, and even though they've made application for a business license, was that they were not operating.
Yes, sir, and there is an extension with Clark County. Perhaps you could provide a little bit more color on that, please.
Yeah, so this is Daniel Friedman for JDW Nevada. We are working through the licensing process, but we're also working through all of the building approvals and the various public works. And so there were steps that needed to be taken, and we're still working on some of those approvals, and that they were prior to getting that exact license. And so it's on our list to do once we work through all of the different stages and all the different steps. So we're on track with it, but there were some things that had to happen before we got that done.
If we additionally could have just the introduction of those individuals who have joined us via the internet.
Do you want them to do, or you want me?
Just to.
Okay, yeah. So we have.
Hi,
yeah, there we go.
I'm Kathleen Watson, Dr. Watson's wife, and now the CEO for JDW Nevada.
Good morning. My name is Taryn. I am the point of contact for JDW Nevada.
I'm Robert Brahms, and I am the president of Harmony, Nevada.
Thank you. Questions or concerns of any board member this morning?
Member Dret, so what are the plans? Has it never been operational? And so what are your like 5-year plan, for example?
We're not operational, but we have been in the process of constructing and building our facility. So it's going to be a almost 30,000 foot state-of-the-art lab that will be able to basically be a contract manufacturer and a producer for a whole host of cannabis products. And we're really excited about the project. We're doing modular construction, so they're cubes basically. So we have those all done, and we're just working through the actual putting the cubes on the property, hooking it up to water and electricity, and we're working through the entire process to see that happen. We're hoping to be operational by the end of this year, but most likely Q1 of 2024. And unfortunately, we've had some delays due to COVID originally, and then also due to a civil engineering firm that without notice walked off the job on us, unfortunately. And so we'll deal with that in front of a different government body to deal with that party. But we have a new civil engineering firm who is working on it, and we're looking to get our approvals by the end of this week and get things right back on track. So that's where we're at.
You're counsel, right?
Yes.
Are you also helping with the business aspects too, or just representing them on the legal work?
I feel like I wear multiple hats as most in-house counsels do these days, and especially with a startup business or early stage business.
Oh, I didn't realize you were in-house. Okay. Maybe the owners and managers are already very familiar with cannabis, but I highly recommend touring a couple of facilities. Nevada's facilities are typically they're very competitive, but it's a friendly competition, and they will can give you some good guidance on what to expect. And it's a lot, and there are going to be some very painful, eye-opening experiences. And so I would highly recommend getting to know some of the owners who've already had these growing pains and challenges, and they likely will, like I said, give you tours and give you some lay of the land.
It's a great suggestion. Absolutely.
May I speak on that just for a moment, please?
If you wish.
Yeah, we're the operating partner, and we signed on with Jeff and Company 4 years ago, and we have a very successful multi-state operation currently. And I certainly appreciate your advice. And we've been to many, many places. And yes, Nevada, especially Las Vegas, is very unique. But we're confident that will be entirely capable of producing and providing good quality products to the Nevada market.
Member Durrett, part of what gives me a little concern is that you keep calling it Nevada instead of Nevada.
Okay,
so you need to spend a little more time here.
I apologize. You're right. And the first thing I wanted to say was I wanted to thank you for the accommodation of allowing us to do this by Zoom. I had a tragic death in my family last week, and I was unable to be there in person. But you're 100% right, and I'm sorry I made that mistake.
Any other board member? And then my comment for the record, what is before this morning is a simple transfer of interest. However, there was another issue that came up while looking at this as to the involvement of Tampa Bay in this. It's not good or bad at this point. It's just something that needs to be explored, because in essence, what was given to us on the surface is turning over full operational control to this entity who has not been licensed. I understand there's potentially plans for them to come forward at a later date, but the way this is written up, what we have been privy to, it says they will have complete control even over the other members. And so it's like an unlicensed person running this company. So there are concerns. Hopefully they can be dealt with. But that's something that you probably need to talk to our staff about after this first thing is approved this morning, so that nothing runs afoul and you're successful in doing what you want to do.
Thank you.
So with that, we have the motion for requesting approval of our transfer of interest. TOIs 2300006, 2300007, and 2300008, and got one more, 2300009 for approval this date. With that, do we have a member of the board who wishes to make a motion?
Member Durrett, I move to approve the TOIs requested under agenda item 3B, which would also include a approval of the waiver of NCCR 5.110 pursuant to NCCR 5.112 and NCCR 5.125, which would be set to expire on the next TOI agenda date.
If that motion supports, if we have a second.
Member Young, I'll second that.
The motion, we have a second for approval. All in favor, please say aye.
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 Any nays? Any abstentions? Motion carries. Thank you very much. Good luck. And as I said, you need to have a conversation with our in-house.
Thank you. Thank you.
That moves us along to Green Cross of America, Inc. Member Durrett, you had something that you want to state for the record?
Thank you. Member Durrett, for the record, I wanted to make a disclosure that counsel for Happy Cabbage LLC has represented me recently in a legal matter. It was after the last board meeting date, and it's already, the representation has ended. But I wanted to disclose it and to avoid any appearance of impropriety. I don't believe it would have any impact on my judgment. So I'm going to go ahead and vote on the matter. And it sounds like a DUI when I say it was one, but it wasn't. It was a business matter. It wasn't criminal.
Do we have a representative on behalf of Green Cross of America, Inc. Present, please?
Chair Douglas, members of the board, for the record, I'm David Staley, Chief of Investigations for the CCB. Item C is a TOI application by Green Cross of America, Inc. Green Cross was placed into receivership due to financial issues and a prior summary suspension and disciplinary complaint by the CCB. Kevin Singer was appointed as a receiver over Green Cross and negotiated the potential sale of Green Cross to John Harp through his company, Happy Cabbage LLC. TOI 2300010 was filed requesting approval for Happy Cabbage to purchase Green Cross's cultivation licenses C035 and RC035. An area of interest was developed during this TOI investigation relative to the business competence and experience of Chad Harp and Marjorie Fregoso, who will be running the day-to-day cultivation operations for Happy Cabbage. I am available for any questions. My understanding is that Maggie McCletchy, Derek Connor, Kevin Singer, John Harp, Chad Harp, Marjorie Fregoso are available to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
So we can properly tee it up before I go to the parties on the other side. What were the concerns as to ability to manage? So they can at least respond to that.
I'm sorry, thank you. During the investigative review, we found that Chad and Marjorie both had experience in operation side of cannabis, but this will be a new role for both of them in that it will be the overall management and executive decision.
Mr. Chairman, we can't hear what's being said.
Okay.
Mr. Staley, first one.
This is, nobody has ever told me to talk louder. So the area of interest was because, well, they had operational experience in cannabis operations. This is the first time that they're going to be in a management and an executive oversight role. They're different skill sets, and we felt that it was important for the board to possibly have that conversation on the board.
Thank you. Now, if we can have our introductions and your comments.
Sure, I would be happy to. For the record, Maggie McCletchie, I represent Happy Cabbage LLC.
Derek Connor of the law firm of Connor and Connor in Henderson, Nevada. I represent Green Cross of America, Inc.
And Kevin Singer, I'm the court-appointed receiver for Judge Denton.
Thank you.
And if you'd like me to, I can certainly address, and it was, by the way, just for point of clarification, it was an area of interest, not an area of concern. Is that correct, Chief Investigator Staley? Thank you. Happy Cabbage, with these licenses that have a troubled past, has a challenge ahead, but it is ready for that challenge. Happy Cabbage is a small family-owned and run company, and that's more and more rare, so it's nice to see. They're ready to hit the ground running. They have a year from today, pursuant to the settlement agreement on the disciplinary issues for Green Cross of America. They've already gotten their SUP in Nye County. They have a team already, even though they only have the building and they still have to perfect these licenses. Mr. John Harp here with me and is happy to answer any questions. Has extensive experience as a CEO and owner of businesses, including construction businesses. He worked for publicly traded companies. He also happened to be a legislator in Montana for many years, but he does know how to pronounce Nevada. And this is truly a family operation. Chad Harp, Mr. Harp's son, has extensive experience growing, and together with his father's extensive high-level business experience, we think that they have more than the skills needed to get these troubled licenses finally to good, clean, compliant operational status. We also have Marjorie Fregoso here, and Marjorie Fregoso has bookkeeping, management, and medical field experience that she will help put into use in the day-to-day operations along with Chad, the master grower. Obviously, they'll be hiring others, but Mr. Harp will not be an absentee owner. He's the CEO and owner. And while he won't be there every day growing cannabis, he will be ensuring that this business is run in first of all, in a business-like fashion, as he's done in all the businesses that he has owned and run over many years, but also in a compliant fashion. And I'm happy to answer any further questions about the team, and they're also happy to answer any questions that are all here in person today.
Thank you. Other representations, and I'd like to hear from the receiver. Where are we with this?
I mean, today we're looking to get the transfer approved by the board. But if this transfer happens today, it'll transfer the licenses and the responsibility over to a responsible party. It'll pay the fines and penalties assessed by this board, and we'll have some funds to distribute to the creditors. So I believe with your vote and your help today, we will accomplish all of our goals. Thank you.
All right. And counsel, you wish to make any representation? So,
Yes, thank you, Your Honor. I think that this is a good example of where the system is working properly. Working with Mr. Rath and Mrs. Boardlove, we really came to a resolution for what a license that didn't experience much success. And hopefully it is transitioning to a new party who will be able to take it and make lots of money, pay lots of taxes, and we'll see a nice result out of something that otherwise was headed in a very negative direction. So I also want to thank Mr. Staley and his staff and this board and rest that you approved the TOI today.
And I certainly did not mean to forget to thank Chief Investigator Staley and Rachel Branner and Dana Lauren, who all worked hard to get this on this agenda so that this could move forward, which is important to my client, to the creditors and the receivership court, and certainly will allow these licenses to move forward. I also wanted to let the board know that obviously the TOI was conditioned on two things, both the approval from the receivership court and this board's approval. We already got, I worked with Mr. Singer's office to make sure that got done quickly, and that was in our purchase agreement. That has already been done. Again, Happy Cabbage LLC has already gotten a new property, total clean slate in Nye County, and they've already obtained an SUP. So I would request approval of this TOI today.
Thank you. Board members, any additional questions?
I have a question for Mr. Singer. This seems like a very clean transaction, so I think it's, I want to ask about how you found.
This is Member Young. We can't hear you. I'm sorry.
Can you hear me now? Yeah, I don't think the mic's working.
You want to try that one?
Okay. Working better. Sorry. Okay, Member Direct for the record. So this seems like a very clean transaction. So I'm wondering, what was the process to find a new license? Some of the receivership actions are not as clean. They're a little opaque. It seems like it could be a way for somebody to come in who wouldn't have qualified in the original licensing round. I mean, they still have to go through the suitability investigation, but I'm just curious, what does that process look like, since it doesn't seem like there are any problems here? I'd like to know.
Well, thank you for the compliment and saying it was so smooth, but it's been about almost a year and a half process, and this board's been great all through the process, which we really appreciate. But the way that this came to being was that one of the creditors of the corporation wasn't getting paid, so they filed a lawsuit against the business. And one of the things they asked, because the business was basically out of business, was to put a court receiver in charge to take control of the licenses and go through a process to try to sell those licenses in order to generate money to pay the fines.
I'm sorry, but how did you find Happy Cabbage, or how did Happy Cabbage find you? How did that?
I mean, it's a very transparent process. We marketed it. We hired a broker who specializes in marketing cannabis businesses in Nevada, and he did an open to everybody and anybody who wanted to participate in it, and that's how the process came about. And we
Okay, that's what I was wondering.
Many buyers, and this happened to be the best and most qualified.
Thanks.
Thank you.
And Mr. Singer and Mr. Connor make it seem easy today, but the receivership process was actually quite complicated. And we had to ensure liens attached to the licenses with prior owners. And I want to thank them both. They worked very hard with this sort of dual track or CCB process.
Thank you.
Any other board member wish to raise a question? If not, can we have a motion for approval?
Member Durrett, I move to approve the transfer requested under agenda item 3C.
Do we have a second as to that request?
Member Freilich, second.
We have a motion, we have a second. Anything additional? If not, all in favor, please say aye.
Aye.
Aye. And note for the record that Member Merritt is not available at this point. She will return, but so it's a 4-0 vote. Thank you. And for our Montana friends, welcome to Nevada.
They've been here for some time, yeah. Thank you.
Thank you.
Our next item up is item D, medical cannabis. I know that one. Are we going to push both?
Yeah, medical cannabis.
Okay.
That was their request.
We have items D and E both are going to be continued for 1 month at this time. That is medical cannabis healing as well as MJ distributing. So they'll be past 1 month, which takes us to consideration for adoption, amendment, and or repeal of the Nevada Cannabis Compliance Regulation. Regulation 5, licensing, background checks and registration cards. which is in our NCCR 5.02. And I think it's probably best to take these two items, 1 and 2 separate, so take one first.
Good morning, Chair and board members. For the record, my name is Michael Miles, Deputy Director of the Cannabis Compliance Board. Before you, for adoption, are the proposed changes to NCCR 5, which creates a licensing process for a county-specific medical cannabis establishment license for counties where 0 licenses have been issued. Initially, the first part is NCCR 5.020. This just updates the language to include all licensing types. It was very specific to consumption lounges. Now it opens it up to all licensing types.
Is it, even though I separated, based upon the intermingling of some of the activity, should we take all of them at once and our comments, or is it-
As many times as we've went over this, I should probably let me do a summary of all of them, and then we can have the comments at that point.
Go ahead then. Thank you.
Right, NCCR 5.035 creates a petition process for counties who do not hold a medical-only cultivation or production license facility. Again, this allows a county to petition the board to create a licensing round for those licenses. NCCR 5.042 creates a new regulation for medical-only county-specific application process. This process is similar to the process for consumption lounges. The criteria of merit listed in the initial application are all weighted equally. These requirements must be met prior to moving forward to the random number generator process. NCCR 5.047 creates a new regulation for medical-only county-specific prospective and conditional licensing process. Those that met the minimum scoring guidelines in 5.042 will be entered into a random number generator process. If selected by this process, again, a final license is not guaranteed. All it means is that the potential licensee has moved into a prospective license status. At this point, there is a long list of criteria of merit that must be submitted to the board to move forward with a detailed suitability analysis. If the board ultimately finds that licensee is suitable, the potential licensee is moved from a prospective licensee status to a conditional licensee status. At this point, that potential licensee still is not guaranteed a license. NCCR 5.052 and creates a new regulation for the final steps of the medical-only county-specific licensing round. Here, the potential licensee must meet a few final steps, which include become operational within a time limit set by NCCR 5.085. Also, other various building and local ordinance requirements and fee requirements. Again, this process is very similar to the consumption lounge process that we just began several months ago. Back to you, Chair.
All right. With that, I'd like to open it up for short public comment as to this particular item and the amendments. We've heard from people earlier, but I think it's appropriate now that the item's actually before us. I note that we received a letter from White Pine County and its Board of County Commissioners that have issues as to the lottery. Also, the Nevada Cannabis Association submitted a letter. We have our continuing concerns from some other individuals. So I open it up if they wish to make a short statement or just say that, let us know that they still stand by their prior statements. If they wish to do so, please come forward and make your statement as to going forward with the change. Yes.
Good morning, Chairman, members of the board,
Executive Director Amanda Connor with the law firm of Connor and Connor. I have previously commented at the public workshop and other hearings on these proposed regulations. I am here today to reiterate my comments. NRS 678B.2203A says that the board shall issue at least one medical cultivation and one medical production company in each county. There is no option to deny the request of a county in statute, yet the proposed regulation 5.035 subsection 3 gives the board the opportunity to deny such a request if it finds that it violates statute or will not promote the health, safety, morals, good character, or welfare of the state of Nevada. Again, the legislature said shall and did not give the option to deny. So I feel that that proposed regulation is contrary to the statute. Also, NRS 678B.210 subsection 6 requires that when determining whether to issue a medical cannabis establishment license, the board shall consider criteria of merit. And nowhere in the medical licensing statute does it permit a lottery or random number generator. In fact, only in statute, as pointed out by the Nevada Cannabis Association, is a lottery permitted for adult use consumption lounges. The legislature had the opportunity this session to amend the statute to allow for a lottery, and to date, they have not elected to do so. And so I think it is improper to move forward with the lottery in contradiction to the statute. Lastly, pursuant to NRS 240, or 678B.241A through J, there are certain criteria of merit for a medical cannabis establishment that the board shall consider. And in these proposed regulations, certain criteria that the statute mandates be considered are missing, such as the knowledge, expertise of proposed owners, officers, and board members with respect to the compassionate use of cannabis to treat medical conditions. That is required by statute to be a criteria of merit, but it is not in these regulations. Therefore, I feel that these are not at a point for adoption, and I would kindly request that the board consider these and amend them to be compliant with the statute. Thank you.
Do we have anyone else who wishes to comment in Southern Nevada? Anyone up in Carson City that wishes to?
Hello, good morning,
morning.
Chair Douglas, board members. Lake Martin on behalf of the Nevada Cannabis Association. And we submitted detailed written comment, so I won't take too long. And I want to echo the comments of Amanda Connor regarding the statutory requirements. We reiterate our previous comments in April and December that the statute requires the board to use criteria of merit to evaluate applications. And the board must set forth relative weight of that criteria, which it hasn't done so yet. With the use of a lottery, some applications will not be reviewed based on merit because they'll be eliminated before they have that opportunity. Also, it doesn't set forth the relative weight. So we ask the board to not approve the proposed amendments to the NCCRs because they contradict the statutory requirement that the applications be evaluated based on criteria of merit. Thank you.
Good morning.
Good morning, Chair. Members, Brett Scolari with Strategies 360. I just wanted to echo the comments of Ms. Connor and Ms. Lake Martin. We are in line with those comments and ask and request the board to follow the statute on the merit-based criteria. I'll also point you to a suggestion, and this goes to the comments made by White Pine County. You do have an additional tool under 678B.2401J, any other criteria of merit that the board determines to be relevant. And so that would give you a tool to look at the community that is being affected by this license and consider factors such as economic development and any other factors that might be important to that community where that license is going. So we would appreciate your consideration of these comments and request that you pull this regulation for further consideration. Thank you.
Thank you. Anyone else in Northern Nevada? Do we have anyone else?
Will Adler, representing the Sierra Cannabis Coalition. I would like to point everyone to the written comments from White Pine County. I think they're extremely well thought out and well structured. I think they put a pretty good point on this. I would echo and ditto the comments from Brett Scalari and Lake Martin as well. I think that a merit-based system is kind of the developed process in Nevada, and it is one that most licenses were given out under. And I do think that as that is still relevant in statute, and the legislature has yet to make that a decision to not have that be the process, and they have no bills doing that today, and we don't see that going through the legislative process today. I think the lottery system we have before us is a little preemptive and or not quite the right way we want to be doing this, because it does sort of leave it to nothing but chance. And there are a lot of operators putting a lot into these operations, especially the one in White Pine County. So thank you for your time.
Thank you. Anyone else up? And do we have anyone online?
There is no one online to provide public comment.
Mr. Miles, would you like to kind of respond to what was given to us before the board engages?
Absolutely. The initial comment made that 5.035 allows you to illegally deny a petition. It isn't accurate. There is one criteria that would allow you to deny it, is if they already had a medical only license in that county, then you can deny the petition. That's the only reason why that's there. There's nothing in the statutes that prevent a random number generator to be used in this process. Criteria of merit is used throughout the process. Criteria of merit is used prior to the random number selector on an equally weighted basis. Criteria of merit is also used in the suitability analysis. Again, there's a huge list of documents and criteria that must be submitted to the board for the board to review and determine if that licensee is suitable, and can and likely will be denied based on not being suitable. There's also, I think there's also a comment about the life experience of the licensee. However, there is a specific criteria of merit under that specifically talks about the education and life experience of the persons who are proposed to be owners, officers, and board members of the proposed cannabis establishment. So that is also included. Again, this process, to continue calling it a lottery, is a vast mischaracterization of what's happening here. This is not, you're putting up some money and you're going to have a chance of receiving this user asset. Here, you're going through a criteria of merit process in the initial application. If you meet that process, yes, you have to pay an application fee, then you're in a random number selector. This only gives you a chance to potentially get a final license. You again have to go through a lot of other steps, which will be a lengthy and detailed process to potentially be able to be granted a license. Again, criteria of merit is not cut out in any way, shape, or form, and is an absolute requirement of the new process.
Thank you. Board members' comments.
Member Drat, for the record, I think, Mike, did you say, I don't want to, just say like, oh, gotcha, or make it semantics, but you said criteria is evaluated on an equal basis, but the statute specifically says that these areas will be given relative weight, which is like a nice way of saying rank them.
Yeah. And no, it's just, we say they have to be given a weight, and to be given a weight, they're all given an equal weight in that initial application process. So it ends up becoming a binary weighted process. Either you meet all the requirements or you don't, but it is a weighted criteria process.
So I think that is kind of twisting what is meant under the statute.
Well, it may be changing what was initially done on the first round back in 2018. I don't think it's twisting it at all. It's allowed under the statutes. Again, we have legal opinions as it's also allowed under the statute.
Okay, so I think that, I've also heard legal analysis on the other side that I think really makes sense by very well qualified attorneys as well. And I think their input should be, I mean, like I've always said, we need to listen to the industry. We don't have to do what they say, but we need to listen to them. I think what they've said is very well informed. I think it makes sense in the statute. I think if we don't follow what the legislature does here, we're just, getting away with kind of misinterpreting the statutes. We know what they mean, and what they mean is to have a weighted ranking process. I don't know that that's the best way to do it, but that's what the legislature has told us to do. There was an attempt to change that and that failed. So we are stuck with this, whether it makes the most sense or not. And I think anytime we're evaluating regulation, and I am going to say this until people are sick of me, we have to look at the preamble. We have to look at what are our priorities. Our priorities are tax revenue, public welfare. There's language about making sure these licenses are representative of the community in our charter. A random number generator does not make sure that the license is representative of that community. And there are other factors to consider when doing an application and an evaluation of that, but we have to look at what we've been commanded by the legislature. We have to look at our overarching public policy. There are reasons to do a random number generator. There are good reasons to do it. Unfortunately, we don't have the authority, and those reasons are not set out in our preamble, which is potentially going to be changed very soon, but still the priorities laid out in that are not the ones that are compelling to do a random number generator. Mr. Chair, that's it. Thanks.
Is that the recorder? No, that's. Please go ahead.
Thank you. First of all, I want to thank staff. I know that we've been asked to deal with this and put this on our radar and our agenda, and I think that they've done a great job to try to fulfill that request. I also want to thank the industry for trying to come up with better ways or something that will fit with our with what we're supposed to be doing and what we can do and what we can't do. I don't know if we're there with what we have. I just want to make sure that we have the authority to do what we're trying to do. So I would want to ask the Attorney General to just stay on the record whether or not we have authority to do what we are trying to do with this regulation today. And that would help me make up my mind as to what we have before us. So with that, if I could have the Attorney General just kind of explain on the record whether or not we have the authority to have the regulation that we have in place. I would imagine that everybody else would like to hear that on the record as well. Thank you.
Thank you, Member Freilich. L. Christopher Rath, Senior Deputy Attorney General. Yes, we have looked at this. I do agree with Mr. Miles' assessment of this. There are factors of merit that are to be considered in the statute. And similar to the way it was done for consumption lounges, there's an initial application which lays out certain criteria of merit that the applicant must meet before they even get to the number generator. Those include, for example, liquidity, and CCB would structure the initial application so that the basics are covered. So, the company's got to pledge that they have enough liquid assets to proceed, that they have certain basic requirements for experience and that type of thing. And that's the binary process where you get a lot of your criteria of merit evaluated. The second process would further evaluate the remaining criteria of merit through the suitability evaluation. So it's a two-step process, but all the criteria of merit are considered pursuant to the statute. As to the random number generator, again, you've got to meet certain criteria before you even get to that point. So it's not just a pure lottery. Additionally, we may have more than one qualified person applying. There's got to be some way to sort this out when you've only got one license available. I think it's the most fair way of proceeding. There shouldn't be any preordained licenses to begin with. Everyone's got to go through suitability. Everybody has to have their criteria of merit evaluated. And I don't think there's anything prohibiting a random number generator either. The board is charged with coming up with a process that's fair, equitable, and considers the criteria of merit. So that's my basic opinion. If you have any questions.
Can I ask a follow-up to that? Unless member Guzman Frelick has more. Okay. So consumption lounge language that allows for random number generators in statute, right? So the legislature specifically said it's authorized, right?
It is.
Okay, thanks. And they didn't do that on these other establishment licenses, just consumption lounges?
That's correct. But again, this is a limited licensing round like consumption lounges. We're only looking at one license here per county.
I guess this is Chair Dr. Sutter. I guess to your point, the consumption lounges, that came into play with a whole slew of new regulations, and other regulations weren't touched the previous because they weren't open at the time. Why or why not, I don't know. So I can't comment on that as you were trying to go. But when the previous licenses were placed before the public, we didn't have consumption lounges, the rules, the regulations. We didn't have the set aside for disenfranchised groups to be included in. The legislature did not authorize that. And so since I'm speaking, I'll continue to speak a little bit. I support the process. I support the process because previously, the previous process instituted a major call for lawyers are us, and a good payday for a lot of lawyers for a number of years. And part of that litigation is still going on as to merit selection or not merit selection, who had inside information, who didn't have inside information. I don't know what the truth of the matter is, but that's the reality of what was there. Additionally, the statistics that Cannabis Compliance Board has found the process being fair. No, it's not been fair. When you look at the number of women or you look at the number of minorities involved in the cannabis industry, they're pitiful by comparison. So fair is a very subjective word. What we're trying to do is make this as open as possible, not to discount newcomers for old timers who say, I've been doing this forever. Why are you letting the young whippersnappers get in? They don't know what the hell they're doing. Well, legal cannabis, to my knowledge, is a relatively new business. And some of the people with the most experience are the old timers who are, quote, the illegal cannabis, but they've been left out. So fair is a very operative word. So what we've tried to do is look at the statute. The statute requires merit. We've included merit. So then you get to the point of saying, okay, you've included merit. How do you make the final cut? Whose glass of water, so to speak, are you going to steal by not giving them a chance? And I speak like this because every time I look at one of the publications I get, once a week, there's another lawsuit in some other jurisdiction where licensees are suing the licensing agency because they say the merit selection was not fair. Somebody said you had to be green, and when they looked at it, said, well, you weren't quite green enough. Well, that's in the eyes of the beholder. Member Durrett and I agree, we disagree. Doesn't make one right, doesn't make one wrong. It's just our position. And that's the problem sometimes with the selection. Everybody has it there, you don't. We had issues raised earlier about licensees because of random number might be squatters. Well, we have some of those. I agree. I won't disagree. They got licenses, they didn't act. We have a number, though, who got licenses. And the only reason they did not go forward with the license is because of moratoriums on jurisdictions that they received licenses for. They weren't squatting. They just couldn't go forward. And they were attempting to change the law of the land. That just occurred in Friendly Henderson. They just opened it up for retail stores, not having certain things before. Now they're allowing more. We had rural jurisdictions that said no cannabis whatsoever, but folks took a fly to get some. So now some have opened up, and the people that had those quote licenses move forward once they satisfied the requirements of the county. Yes, I agree that sometimes it's a crapshoot, the economic development aspect. But how do you fairly exclude people that on their face are qualified? What makes you more qualified than someone else unless you can see into the future? And none of us can see into the future. We just hope that we'll get the outcome we're looking for. I think the process we're doing, requiring merit and saying if you meet the merit, you can get into the game, you get your feet wet, then we still look at you to make sure you meet the merit. I want to believe that is the intent of our legislature, who is supposed to be the legislature of all people in the state of Nevada, not just some people in the state of Nevada. That's my take.
Thanks, Chair, for indulging me. I think there's benefits to doing a random number generator, of avoiding lawsuits. It may appear to be giving everybody a more fair chance. I don't think it actually does, but that is not what the legislature set out. The legislature adopted its language ultimately after question 2 was adopted by the vote of the people. The legislature added the language relating to criteria of merit. We did a ranking process under that language, and the legislature has declined to change that. Again, any positive any benefits of doing a random number generator do not satisfy our driving goals, which are set in statute. Those are economic based primarily. Our number one directive or policy is that this is beneficial to the state of Nevada. The proposed change is to say that it's significant. That mirrors the gaming preamble, which states that it's vitally important, meaning the legislature has said this is an economic engine of our state, and that is our number one priority. I see value in doing a random number generator, but this is the way the legislature has set it out for us. Now, in that preamble, it also states that we are going to strive to issue licenses that are representative of the community. We also have language directing us to take DEI issues into account. A random number generator does not do that. It does the opposite. Currently, our criteria of merit says that one of the qualifications is diversity, not social equity, but diversity. A random number generator does not take that into account. So any priority goals that we have, which have been laid out in statute, are not taken into account by a random number generator. And those are our highest priorities. Avoiding massive litigation is smart. It's the right thing to do, but that's not what the legislature told us to do.
I appreciate the comments, but the reality, as I said, is fairness is in the eye of the beholder. Things that we wanted to put in the statute, we are precluded from putting in the statute. We are precluded from saying you must be a resident of the state of Nevada for so many years. We can't do that. We looked at certain plus points for military or female or disabled or whatever. You can't do that. We had a lot of can't do's. And so you want to tell me that the only thing that is importance is money? You're presupposing an outcome of something that we don't know. Operators are going into it to make money. They're not going into it to lose money. And yeah, maybe on its face, one operator is going to make a bigger profit than the other. I just don't know. But I would like to presuppose that whoever gets a license up there is getting a license for economic reasons for themselves and that county that they're working in rather. And no offense to the legislature, sometimes we know exactly what they're saying and we think we're right in following it. And it turns out, gee, they meant something else. And sometimes it goes the other way. Or the legislatures that adopted it is not the same legislature now. And I will be silent as to some things that are pending presently before the legislature. But we are faced with the conundrum right now of we are looking to allow White Pine to go forward and get a license if we adopt this. At the pace we've been going, or we're going to have to start all over again. I, for one, think we meet the intent of merit, even though we have not altered it. I think we've managed to get ourselves into what is considered the gray area, so it would be allowable. And it didn't, in retort to the other comment about it didn't say we could not do that. It did say we must have a merit review somewhere in the analysis, and we are doing that. So if we have anything else from a board member, so if not, if the board wants to take 5 minutes, we can take 5 minutes and come back on the record and then see what kind of vote we're going to have, or the board can vote now. If folks would like to take a 5-minute recess to think about this some more, we can take a 5-minute break. If they want to go forward with it as it is, do that too. Let's take 5 minutes off the record. We'll go recess until, based on the clock on the wall in the back, 10:35. We'll come back and see what kind of motion we get. Good to go. We are out of our recess. We're back on the record. At this time, we are dealing with proposed regulations 5 et al. The board has been in discussion as to feelings and concerns, pro, con, somewhere in the middle, as the regulation, with the intent to look at what they think is in the best interest at this time. And I'll leave it at that. And the question is if we have anyone who's ready to make a motion, whatever that is, or if there's any further discussion.
Okay. I'll get this over with quickly. Member Durrett, I don't think we have, I think it's clear that the legislature hasn't changed our current process, and they were very clear that how they wanted it with consumption lounges. They declined to follow that process in consumption lounges. I think if somebody wants to change that, they have to do a bill, change it, make all the arguments about the way it should be done at the legislature, and maybe it shouldn't be in a bill with other matters so that there could be a focus on this issue. I'd love to have a much more extensive policy discussion on this. So I move to deny the proposed changes.
We have a motion for denial of the proposed amendments to the regulations so stated. Do we have a second? I note for the record, if we have no second, then that would fail. So I ask again, do we have a second? We have no second at this time.
Mr. Chairman, if I could just,
Yes.
I will second just for discussion purposes only at this point, because I would like to have a discussion on that motion.
All right. We have a motion. We now have a second from Member Freilich. So now we move into discussion on the motion.
Member Durrett, for the record, thank you, member, for seconding that. I incorporate by reference all my previous comments. We're just stuck with what the legislature has stated so far. I don't think it's our role to find gray area and then make a major policy change based on what the legislature has ordered in the past because we can. I think we have to relate everything we do back to our preamble. I will never adopt a regulation or deny a regulation without filtering it through the lens of the preamble, but we also have a very clear statute here. So that is why I'm moving to deny.
Mr. Chair, if I could.
Please.
So I don't want to throw the baby out with the bathwater. I think we're making progress, and I think that's good because that is our job. And I would like to finally see this go through, but I don't believe that we're there yet. And so I don't know what the best way to move forward would be, whether we send the regulation back to staff with instructions to hold another workshop and have further amendments, or whether we just postpone this regulation until June or July, thereby giving the legislature maybe, I don't know, somebody will sneak it in the last minute, some bill, and clean it up. I'm not sure, but where I sit here right now, I would hate to start all over, because I think there are some really good points from staff as well as the industry, and and the individuals that have written in their comments. So with that, I would love to hear everybody else's comments.
Any other board member wish to make a comment? In line, I will make a comment. Chair Douglas, for the record, I will make a comment in line with what you are advocating, Member Freilich. Our regulations are susceptible to review by the legislature committee so many days after they're passed. If they decide to be concerned with what we're doing, they can bring them up to a legislative group who can either review them and say they'll let it go, or they can say, no, they send it back to us with instructions to do it this way. They would have an opportunity to weigh in if they so saw fit. So I think there's, if you will, a safety valve if we do adopt this for, as Member Durrett said, for the legislature to speak directly to us and say, no, this is how you're going to do it. We don't agree with your saying you have authority to do it in the gray area. So that's another consideration. Any other board member wish to weigh in before I call for the vote on the motion? Hearing no other discussion. We have a vote for denial at this time of the proposed adoptions that reference Regulation 5. All in favor of the motion for denial, please say aye.
Aye.
Member Durrett. Any other members voting on the motion for denial at this time? Members opposed to the motion for denial at this time? Aye. Would be opposed to that motion
Aye.
going forward? Who was the person speaking, please?
This was Member Young.
Can I just get clarification?
Yes.
Okay, sorry. Chairman, so we are voting nay on the motion to deny?
We're voting.
Or am I making it more confusing?
The motion, the motion that was on the floor was not to go forward with the proposed adoption at this point. The only member who voted for that was Member Durrett. We now move to the other side motion to see if we have a majority that would say we don't support that motion. And right now we have two people, Young and Douglas, who are saying we don't support that motion. So that's where we're at. So whether we have any more that do that or whether other members wish to abstain. So again, I'll start back from the top just to make sure it's clear with everyone. We have a motion on the floor to deny adoption of the amendments. So this vote is, the first question is all in favor of that motion to deny amendment?
Yeah.
We have a nay from Member Durrett. Do we have anyone else with a nay as to this motion? Nay, aye. Okay. You support the motion. Anyone else? I hear no one else at this time. Those who wish to not support the motion to deny adoption at this time. I support not adopting the motion on the floor to deny adoption of the regulations.
This is Member Young.
Anyone?
Again, I support somewhat of the double negative to not adopting.
Aye.
Is that Member Freilich? And Member Young, do you wish to abstain or do you wish to? How do you wish to vote on this? Excuse me,
I vote.
Excuse me, I'm looking at Member Merritt and I'm saying Young.
Yeah, I voted. I'm sorry, I must have been on mute.
Okay, you're voting to deny the motion or you're voting for the motion to deny adoption?
I'm voting to deny the adoption.
The motion fails 3-2 then, if I understand the math. So now the question is, do we have another motion? And I understand that there's some concerns raised by Member Freilich on this.
I'd like to make a motion to send this item back to staff for further consideration at a later time.
Member Merritt, I would second that.
We have a motion to send this matter back to staff at this time for further consideration. We have a second from Member Merritt.
Can I make a comment?
Well, we have a motion, we have a second, now discussion.
Thanks. Member Brett, I think that's a much smarter approach. That's what I meant to do. Thank you. And I just want to say that I do think the proposal that the HG, the staff have their heart in the right place. It makes sense what they want to do. Again, for the reasons, all the other reasons I stated, I don't think it's ready as well. And so I would vote in favor of the motion.
I'm going to oppose it when I call for the vote. Sometimes you have to make decisions, and that's what we're up here for. You can't keep postponing them because you're uncomfortable. Life is uncomfortable, but yet we make decisions. And as I said, there's a remedy. Since the legislature, a lot of things they either sometimes don't understand or they understand differently or different times, or we may misunderstand them. They do have an option to correct our behavior if they so see fit. But I would support the motion, but not the motion, but the proposed change in regulations. But with that said, anyone else wish to make a comment? Hearing none. All in favor of sending these regulations back to staff for additional review, please say aye.
Aye.
Aye. Aye.
It sounded like we had 3 ayes. Anyone opposed? I am opposed.
Member Young, I'm opposed.
Matter carries 3-2. This goes back to staff for further consideration. That moves us to adjudication of disciplinary action. Let me do some first so that for those who do not wish to stay for that entire situation, just for comment, if there's any briefing from our executive director as to what is going on with the legislature, anything else, like to get that out of the way before we.
Thank you, Chair, and I'll be brief. Yeah, we got a couple weeks left, still a handful of cannabis-related bills that we're tracking. Should be an interesting end to the session. Amendments are still being accepted, so we are still engaging on some of the policy issues that are ongoing. And I will look forward to an update in June. Maybe the session will be concluded by then, maybe it won't be, but I'll give you an update regardless.
Well, they keep saying special sessions are us. So we'll see what happens. Our next meeting date is June 20th of 2023. That's the proposed date. I'm going to come back now to, we have adjudication of disciplinary action continued from February 15th, 2023. And that's for the board to go through its deliberation process in public. If board members need another 5 minutes or so to find their materials and set up for this, so we can have a necessary discussion, since we do have a number of items we have to go through. We're not hearing additional argument today. We're not going to discuss what we will do if we have negative outcomes today, only whether or not we find a violation. We're not going to get into the things that would merit at this time if we go there. So just for explanation, but this is our review of what has been had after the administrative law judge, after arguments before this board, and review of documents and papers. So we'll take 5 minutes, let the board members set up, get their material kind of in hand, so we can then cogently discuss what we need to discuss. So off the record. We're good. All right, we're back in the disciplinary matter for the board this time to consider whether or not there were violations, if any, in the Cannex matter. What I would propose as the chair, we have our list based upon what the state charged of alleged violations. And they're also thereafter, based upon the hearing officer's take, she splits up her review into 4 categories: security, records and documents, lab practices, what's the other? One of my tabs is off. And there are 2 additional areas, but we're going to go area by area. I'll read what the hearing officer found, or what the charge was. The hearing officer found, and then any discussion board member wishes to make as to agreeing or disagreeing. State for the record, just conclusion, we were provided with a transcript of the closing arguments to us of the appeal of the hearing officer's decision. We additionally had the briefing that was done both by counsel for Cannex and the state in this matter. And we also had all the volumes of exhibits and the transcript from the matter before the ALJ. And I will state that when I take them out of my house, my house will be level again. It will not shift to one side. And I will get some square footage back in my den. With that note, and knowing that a lot of time and effort, not just by us, but by council on both sides, and I'll say at the outset that this is, anyway, it comes out as a learning experience for everyone going forward. As far as the handling of this, how it's been charged, how it's been reviewed, and trying to possibly in the future see how we can do it better. So security is the first item up, and the first item is complaint. And the complaint was paragraph 83, and it states the complainant alleged in paragraph 83 that as of 2019 inspection, respondent did not have a designated security manager or director who had undergone specific training, including training in theft prevention, emergency response, and security service, as required by NAC 453D.434 sub 7, or have an approved security plan as required by NAC 453D.9053 small d small 6. And that was what the charging was. And in that conclusion, even though they go through the basis for petitioner established that the respondent failed to comply with NAC 453D.434 sub 7 and NAC 453D.9053D sub 6, and the respondent failed to present mitigate evidence as to that violation, mitigating evidence. And we'll worry about categories later if a violation is so in fact found. Any comment as to paragraph 83?
Member Durrett, for the record, I have 2 questions.
One is this, am I correct? This is charged under 453D.905 3D3, which is related to consumption on property. Or that, I'm sorry, that's the, on page 78, findings of fact, conclusions of law. That's what the ALJ has it under, and I haven't looked back and cross-referenced it with the complaint.
Okay, I'm trying to,
So
to gear up in terms of what pages you're looking at. I'm looking at a copy of the ALJ's finding of fact conclusion of law.
So this one, NAC 453D.
Yeah, yes.
Okay, so if you look at 453D.905.
That's 453D.905 sub 3 sub D 6.
Oh, okay, but here it says,
I'm looking at.
okay, so it's a typo.
Not her shorthand.
Okay, so so it's a typo. Okay, okay. So let me look at 6. Okay. Security plan. And one other question is, I didn't bring the transcript from the hearing where we last heard from both the parties, but I believe the attorney for Canex conceded this item. I believe there was a recommendation that this be substantiated. Does that sound familiar? Can I ask counsel that?
No, this is our discussion only.
Okay. I believe that's what happened. So thank you.
There was comment in the record as you look on the document that we provided, the ALJ's findings. There were a number of things that were provided in terms of certificate of training and things of that nature, and notes that certain people had been trained. The concern that was raised was that training actually occurred after the date that the violations were from. So that's one of the things that we had.
So
there was a representation that security training had been had. There was another representation that a later statement had not been asked at the time as to certain training. So the information that the hearing officer at least represented to us in their document was based on what was provided to them at the time of the violations. The people that were presented did not have the necessary training.
Member Durrett, for the record, I don't think it was the last hearing. When we last heard from Canex, there was a concession on a couple of the.
Yes, there were.
And this is one of them.
My notes are different. I don't see the admission. And I'm very careful as to if they in fact admitted it.
Okay. All right. Okay.
Quote admitted.
Right. Thank you.
Anyone else have for us a point of discussion about what was been alleged and whether or not there were in fact violations? And again, we're not into the backside if we do something, but just trying to the front side to make a decision on this. If there's no one else who wishes to weigh in at this time or asks another question, then I would propose that we adopt the finding of fact and recommendation only as to the fact that there was a violation as identified by the hearing officer. And that, as stated, petitioner established that respondent failed to comply with NAC 453D 453.434 sub 7 and NAC 453D.9053 D6. And I would stop there. And Member Durrett, I know you were concerned whether or not they in fact cited the proper violation. So
I like I said, I hadn't cross-referenced the complaint, so thank you for clearing that up.
if that, I would ask, I would make a motion to accept the findings and the legal authority for the violation as to that matter only on item number 83. Do I have a second as to the issue?
Member Young,
Durrett,
I'll
I
second
second.
that.
Motion is second. Any additional discussion? Hearing none. All in favor on that item only, please say aye.
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 Any nays? Any abstention? As to complaint, the next item would be paragraph 84. And I'll just shortcut it unless somebody wants to say something. The hearing officer, after review, and they were again maintain required surveillance systems as required to NAC. I won't even quote it over the allegation of a refrigerator blocking. They established there was no proof that even with a refrigerator, it was blocking the view. So the hearing officer declined to find any violation. So my recommendation, unless someone has other discussions or questions, would be to find no violation, reference number 84, as found by the hearing officer. That was a surveillance of the area by the camera. So with that, do I have a motion to accept that finding? No violation.
Member Durrett, I move to accept the ALJ's recommendation to find no violation on complaint paragraph 84.
Thank you.
Member Merritt, second.
We have a motion, we have a second. All in favor of no violation as to paragraph 84, please say aye.
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 Aye. Any nays? Any abstentions? Carried unanimously. That concludes the first area, which would be our security issues. The second area in the findings of fact conclusion of law deals with records and documentation. And the preamble is under Nevada law, the custody and control of cannabis products from cultivation to final disposition must carefully be tracked through an inventory control system called Metric. And the state approved seed to sale tracking system. That law limits the possession, control cannabis of product to licensed marijuana establishments such as cultivators, retailers, and testing laboratory. Licensees are required to record in Metric each transfer of product in the chain of possession up to and including its final disposition, whether that is sale to or consumer or to a consumer or destruction. Now, specifically, we start with paragraph 85. And the complaint alleges in paragraph 85, respondent failed to document disposal of test samples in Metric between mid-April 2018 and December 2019 as required by NAC 453A.658 sub 4, NAC 453D.426 sub 5, NAC 453D.745 sub 4, NAC 453 3D, 0.788 sub 4, NAC 453D, 905 sub 3, sub D, sub 4, and sub 15. And to that end, the hearing officer states petitioner established that respondent failed to comply with NAC 453A, 658 sub 4, NAC 453D, 426 sub 5, NAC 453D, 0.745 sub 4, NAC 453D, 0.7884, NAC 453D, 0.905, sub 3, sub D, sub 4, and sub 15. And part of the basis was because respondents' SOPs required the destruction. And in this, the critical issue is respondent. It was an issue over failing to hit accept and complete. And in this, for just purposes of understanding the basis, during the hearing, Investigator Wyman corrected the information in the complaint and demonstrated the respondent failed to properly record in the destruction of 10,734 samples, not 12,289 out of 14,305 samples destroyed during that period. Respondent was previously cited. Well, I'll leave that out, but it's there. It's a continuing violation. That was pretty much what was shown. And that is why the violation sits. And I know we've had arguments in closing or of stacking and other things like that, but that's not something considering right now of how we treat this particular topic area. The question of whether or not it was a violation by failing to do that. And we'll see some other areas similar later in the complaint with a hearing officer based on a failure viewed something differently, but that's what we have today. So comments as to this issue. And on that, to your concern, Member Merritt, the administrative law judge, and hopefully it's not in disagreement, the respondent admitted it failed to complete its entries in the metric, admitting failure to update its inventory by metric recording. The response partially from them was they had that information someplace else. And there was an issue as to they were precluded from a period in the metric, and then metric was open, and they still wasn't put in at the time. So those are the pages in between. Page 11 and 12 set it out more specifically than me wanting to read. But that's the violation. So anyone have any comment or at this time as to it being a violation?
Member Dret, for the record, I just want to comment that my understanding is we're just finding whether or not this occurred. It has nothing to do with whether or not we think they should be even disciplined for it. Is that
That's correct.
correct
What we do-
characterization?
What we do on the backside, yes.
Thanks.
As indicated previously, once we do this, and our next step is to set a time for the parties to come forward and make arguments as to what to do with what we found. I would accept the findings of the hearing officer in this case, and that they failed to comply with the NACs as set forth in the hearing officer's report for paragraph 85. Anyone else have anything else to say? If not, that would be my motion to accept the hearing officer's finding of a violation.
Member Freilich, second.
Been moved and seconded. All in favor, say aye.
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 Aye. Any opposed? That carries. That would move us to complaint paragraph 86. The complaint alleges in paragraph 86 that respondent improperly issued one amended COA without an amended banner or explanation of the change between the original COA and the amended COA in violation of NAC 453D.788 10B3 and NAC 453D.9053 D4 sub 8 sub 13. I note on this one that the hearing officer noted that it was a single violation and was a result of computer and human error. Comments or discussion?
Member Dredd. So I don't think that this fits with any of the categories that are laid out. I think, this is something you're not supposed to do, but none of the categories capture it. 3.4 says failure to keep required records. This isn't an incident where they didn't maintain the records. There was like a typo in the record. Subsection 8 says allowing any activity which violates the state of this law, but it hasn't been established that it violated the law. And then subsection 13 is violating packaging or labeling requirements, which isn't relevant. I'm going off the ALJ's summarized table on page 78. So I don't think this is technically a violation.
It is technically a violation in my eyes. The file name of the electronic copy of the COA did not include the designation amended. And that's footnoted 57 on page 13 of the ALJ's decision. Now, whether it's worthy of any more than noting you had a violation, that's a whole different question. So having said that's, Member Durrett, is that still your position in terms of under the not whether it is or not, but it's not a violation of the statute, or whether subjectively you would feel it's not a violation?
We're on paragraph 87, right?
86.
Okay, so I got this, I'm sorry, I got mixed up with 87. 86, the ALJ recommended no violation, right? Okay, I'm sorry. I think our table, I need to not look at this table because the table is inaccurate because the table, it says no violation. Okay, let me look at I'm sorry. Okay, it's still the same citation. So yeah, I'm still of the position that it doesn't fit nicely within one of our categories. So I don't think it was technically a violation.
Yeah, and I note for the record that I would be in agreement with you that it's technically a violation. Any further discussion? We're not in a position where we have to agree. I hope everyone understands that based on everything we've heard and everything we've seen. Going back, again, I would make a motion that we have a single violation. That doesn't say what we do on the backside, only that we had a violation as the 86 amended. I have a motion. There's been no second. That motion dies. Is there another motion?
Member Dret, I move to find that there was no violation under paragraph 86.
That's the motion. Any additional discussion? All in favor of that, please say aye.
Is there a second?
Right.
If not, I'll second it. This is Member Fraley.
Thank you. We have a motion. We have a second. That it not be deemed a violation. Any discussion? All in favor of that motion, please say aye.
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 Opposed? I am, for the record, I'm opposed. Do we have any nays? Now we move to paragraph 87. That is, that respondent improperly issued 9 COAs without header and footers. Footer banners reading research and development or R&D in violation of NAC 453D.77674 and NAC 453D.9053 D4, 8, and 13. And the hearing officer indicated that the evidence showed that they failed to do that. And that was a requirement at that time. Petitioner from the hearing officer found that respondent failed to properly include the required banner on 9 R&D COAs in violation of NAC 453D.7764 and NAC 453D.905, 3D4, 8, and 13. And we know we had an admission as to that. The discussion with the hearing officer was basically why that was important, and what was reconciled in her information was the volume of information that's provided from Cannabis Compliance Agency. Unless they have those banners, it doesn't alert them or in some cases, the industry, that there is a problem. Comment.
Sorry, I didn't, that's what you said. Okay, sorry, member Dret, for the record. I think this is similar to the last one. I'm not going to say this on all the violations, and I don't think we need to have a clearly spelled out regulation for every single activity. They can be types of activities. But I don't think that type of activity is captured in our regulations. This isn't, Hammurabi's code. We don't have to state every single thing that is a violation, but the ones that are cited, I don't think it captures it. So the ones that are cited are failing to keep any required records. This isn't a failure to keep a record. And then so it's 4.8 is violation of any state law. So you would need to 4 would have to be the statute that we would go off of, or the regulation that we would go off of. So I think 8 is just, that alone isn't a violation. And then 13 is violating packaging or labeling requirements. Again, that's packaging and labeling of products, not COAs. So I don't think this particular one could be substantiated.
That regulation, Chair Douglas, for the record, that regulation was in place at the time. I gather that regulation has now been changed from the statement and how it's worded in paragraph 87. But they indicate that it is important so people understand research and development, and also would indicate not for resale, those kinds of things. So it's an internal situation to alert the department and alert other people in the industry so you don't have strange product going out or things that were in limited fashion. So unfortunately, laboratories are probably one of the most important parts of the marijuana industry in terms of the public and their safety. So we probably would lean on them harder, unfortunately, than anybody else, that they do it right. They comply with their SOPs, or they comply with the statutes. There has to be some sanity within that, but nonetheless, if we have the rules, as was been talked about, we have to revisit those rules every so often to see if they really make sense or if it's something that we just get rid of. But it shouldn't be an option whether you follow or don't follow something if it makes sense as to why the rule is there. So I'm on the other side of the argument about following rules that have been dictated.
Member Dret, I don't think that rule has been dictated because I think it is very difficult for our inspectors and auditors, and I don't want to make it more difficult for them to find some of these violations. The nature of the violations are very difficult, and so we have to give some leniency for not holding them to impossible standards to substantiate these violations. But we also need to give the industry fair warning of what is considered a violation. And I think fair warning on that would be language like incorrect labeling on a COA. That's broad enough, but I don't think we would adopt a regulation that says that because I don't think we want to discipline a licensee for that. But that's a discussion for another day. So I think it needs to be a balance between, did they have fair warning? Is this something we wanted to discipline for? Or
we're not disciplining right now, but finding, is this something we want to find a violation for? And how difficult is it to not only find these violations, but substantiate them under the regulations that we have? And under that balancing test that I just proposed, I don't think that there was technically a violation.
The problem is we have an admission by an employee admitted that the failure to properly designate those non-COAs as to R&D was an error. Respondent argued that although it's good practice to include the R&D banner on R&D COAs, it was not necessary. But the party who spoke didn't provide a reason why. Again, we get into a situation of picking and choosing what rules can be followed, rules shouldn't be followed. I think it really goes more on the backside of whether or not on the other side of the argument you feel there's mitigating circumstances to say there's a violation, but you're not going to provide any penalty for the violation. I would see a violation under the circumstances. So having said that, anyone else wish to weigh in, please? No one else weighing in? We have on the table whether or not, as a complaint alleges, respondent improperly issued 9 COAs and it constitutes a violation as set forth. On 87, that would be my motion. Do we have a second as to that?
Ms. Member Young, I'll second that.
We have a motion, we have a second. We have any additional discussion? All in favor say aye. Aye.
Aye.
Aye.
Aye.
Nays?
Nay.
We have Member Durrett, nay for the record. Based upon the document provided by the hearing officer, we are now with complaint paragraph 89. The complaint alleged in paragraph 89 that respondent issued 5 COAs reporting test results for flower samples as test results for trim samples in violation of NAC 453D.905 sub 3 sub A sub 3. And that the hearing officer found that there was sufficient evidence and going to that point, they stated that there were 5 false statements to the department concerning products respondent had tested. At the conclusion of section on 89, petitioner failed to comply with NAC 453A.6521 sub 4 sub 6 and 7, NAC 453D .764 sub 1, sub 4, sub 6, sub 7, NAC 453D 9053D4, indicating that fail to follow Nevada law and its own SOPs. And this is an interesting commentary on the issue of flower and trim, noting that the laboratory received this product from the initiating party mislabeled. And the report that they gave back was as to their testing product as it was labeled for them, even though they were aware that what they tested was not what was labeled. So the argument back and forth to the hearing officers, who had the duty of properly setting forth what had been tested. And there's side arguments within it, but the question is, even though it was marked when it was sent back, clearly the laboratory knew what it had tested. Indicate from their standpoint, even though there's a difference in how much gets tested, that they followed the proper testing procedures. It still indicated this misnomer between flower and trim. So all by itself, it's a very interesting issue, but that's the reality of what the hearing officer had to look at. And if somebody wants to dive deeper into that, they can do so, and we will listen. Dr. Young, I hate to put you on the spot, but you're the scientist. And any thoughts on this violation? Concern?
Yeah, I think it's an interesting question. Was it just an error in receiving the package and just not being able to easily identify, and without, being there and seeing how they receive it, I could see how that could be honestly just a mistake in labeling, rather than an intention, changing of the label to reduce the price. So I'd probably err on the side of human error in that it was probably just accidentally mislabeled. That would be, without being there, would be difficult to say.
Okay.
Does that answer your question? I think
it gives me another insight, and that's all of us are looking for as we examine this. That's what we do.
Yeah, this is Member Young. I think the issue for me is intentional versus unintentional, and I would lean more towards giving the benefit of the doubt and say unintentional.
We allowed to disagree. To that issue, the hearing officer did indicate that they felt it was intentional, but that doesn't mean we have to agree. And I've not done this for a living, worked in a lab. So do we have a motion one way or the other?
Can I make a comment on it? Member Drett,
This one is tough, but I think in addition to it possibly just being a mistake is that I think the responsibility is on the cultivator. They are the ones, who indicate what it is, and the tax is their burden. So if this was intentional, it was on the part of the cultivator.
I would ask to that scenario for you, do we just, if we're in that chain, do we just look otherwise when we get things, or do we correct what we see, i.e. sending it back to the party and say, this is not what you said it is, I'm sending it back to you. Or when they report it as it actually is and not how it was labeled. Is there no obligation whatsoever to give correct information from one party or the other? Where does it start? Where does it end?
They should correct it, but I would ask then, which regulation are they violating by not correcting it? What was cited was making an intentionally false statement. And so I think all we have to do is look at, did they make an intentionally false statement?
Well, they reported what the packaging said, but since they allegedly tested the product, one would hope in that industry they know the difference between flower and trim. If they don't, my position would be they shouldn't be a lab. That's kind of basic.
Yeah, because I also don't work in a lab. I'm picturing maybe it could be somebody who's in the intake process and they don't know to correct it. And so we should definitely encourage training that would lead to correction of these mistakes. But again, the question is, has it been substantiated that there was an intentionally false statement? And I don't think that's been substantiated.
This is a situation like a traffic ticket.
And this is Member Young, if I may, I agree, since I'm not in that setting to receive the package and understand what exactly they're looking at. They only can go by what's on that label, and if the producer mislabels it, I mean, I guess the answer would be training, so that if they should identify it and say, "Oh, this looks like flower versus trim," then that should be sent back for the label to be changed. And I think that falls back on the cultivator.
So Dr. Young, if you got a medical product that was labeled swabs and they were actually needles, and you were then to provide them to needles to a patient or swabs to a patient, how would you react if what you had was different?
Well, I think what I would do is I would whoever was sending me the swabs versus the needles, I would contact them and say, you might have billed me for needles, which are much more expensive, versus the swabs, and that would be to the person who provided the whatever product to me. That's
what we have before us is this part of the inventory control had a responsibility then to report back to the metric system what they had looked at.
Right. I guess I would equate that to if I received two packages of pills and they looked similar and one was labeled aspirin and one was labeled Tylenol, I would take it for granted that the one labeled aspirin was aspirin and the one labeled Tylenol was Tylenol. I wouldn't be able to know from just looking at the pills what the difference is. And I guess that's my point with the package. When they receive it, I don't know what they're looking at. So I don't know if it looks literally like a flower or if it's just a homogenized green organic mass. So because I can't say for sure if it was what they were looking at to say if it was intentional or unintentional. So I would again say I would give them the benefit of the doubt and say it's unintentional just because they're going by what was on the package, what was labeled by the producer.
Anyone else wish to weigh in? Then do we have a motion one way or the other as to this paragraph?
Well, this is Member Young. I will move that paragraph 89 did not constitute the violation stated regarding unintentional statement. Or intentional
We have a
statement, I'm
motion.
sorry.
Okay. Do we have a second?
Member Freilich, second.
Motion second, any discussion? I'm going to oppose the motion for the record only because we're talking about a gateway industry for the activity for the industry and a gateway to protecting the public. As I read what's been before us and the arguments were made, this is something that folks working in the labs, if they're following the SOPs and have been properly trained, know the difference. And I think the obligation is to protect the public, not to protect the lab in this case, because ultimately we have to protect the people out there. That's my soapbox. With that, all in favor of the motion that has been made, please say aye.
Aye. Aye.
Aye.
Dr. Young, are you an aye? It's your motion.
Oh, I'm sorry. Aye. Sorry.
The nays on the nays, that motion passes, not a violation. Even though you would think we would go to 88 next, we're going to 94 next. The paragraph. Complaint alleges in paragraph 94, respondent failed to maintain records when it discarded laboratory testing information, this is my favorite, contained on Post-it notes in violation of NAC 453A, 6521, 4, 6, and 7, NAC 453D, 7641, sub 4, sub 6, and sub 7, and NAC 453D, 0.9053, DN4. And specifically, the complaint alleges respondent used Post-it notes to direct staff to perform various retests, but did not retain those Post-it notes and its records. And to that, petitioner established that respondent failed to comply with NAC 453A.6521, 4, 6, and 7, NAC 453D, 7641, 4, and 6, and 7, NAC 453D, 0.9053D4, and within this argument, the position was they chose to use Post-it notes to transmit testing instructions to staff.
Mr. Chair, we can't hear up here.
Excuse me? In the discussion, it says respondent chose Post-it notes to transmit testing instructions to staff, did not, in essence, maintain them. And the Post-it notes is interesting because even though there was information, it also was alleged that on one of the Post-it notes, I think it was a lunch order.
Mhm.
So there's some humor in what I'm reading today. Comments, please.
Member Drett, I don't think this is a violation. I'm not going to say that about every single one, because it's charged under failing to keep required records. I don't think these records were required. I don't think the facility would have been on, or the industry in general would have been on adequate notice to keep these notes. Whether or not the retesting was a violation is an entirely separate matter. And of course, this is concerning if there was retesting occurring because of, to get different results. That's a different matter about whether they should have kept these posted notes. And I don't think that this portion of the activity was a violation.
To that point, on page 20 of the administrative law judge's record, they said during this period in question, Nevada law requires laboratories to be ISO and IEC certified, adopt good laboratory practices, maintain standard operating procedures, as well as quality control and quality assurance programs, and follow specific guidelines and standards set out in certain publication referenced in regulations. Laboratories were required to maintain procedure for identification, collection, indexing, access, filing, storage, maintenance, and disposal of quality and technical records. Technical records include records of original observations, derived data, and sufficient information to establish an audit trail, calibration records, staff records, and a copy of each test reported or collaboration of certificate issued for defined periods. So that's, I guess, the rebuttal that would be offered as to that. And again, a shorthand, and in there's a discussion about looking to see if there were other things. But the thing that kind of rings through on a lot of these things, they had nice SOPs, and it's indicated quite often they didn't get followed, but they were there. And I understand the position about you're getting, but we're talking about a laboratory that looks at products for the safety of the public. And in other cases, to notify the industry of what's in it, what's not in it.
So I think it's good to address the reference to the other publications, and we discussed these at the hearings. Not every item in one of those publications is an actionable violation. And there should probably be more discussion on what is and what isn't. But I also don't know that that list covers instructions to employees. It covers a lot of things. I don't know that it covers instructions to employees.
It's not about that list if you drill down into it. It's when you have your own internal operating procedures and you don't follow them. You masquerade to the public that you're doing steps A, B, and C, and you're just going from step A to step C. It's like attorneys who bill for time, but they're not there. They just automatically say, oh, yeah, that's another hour. I'm going to bill you for 150. Again, we're talking about laboratories. We're not talking about retailers. We're talking about labs. They're certifying and saying certain things. So when you go back and try to prove something, you're looking for that trail, and the statute requires that you keep certain records, and it's just problematic. And to the point of the comment about ISOs and things of that nature, because it was alleged during arguments about having certifications and things like that. One of the things in here that was argued, and we have material, but certain certifications were not in place at the time of these violations the particular company had. They got the certifications later. That's clearly in the record. So
This is Member Young. I would just make a comment more than anything that uh, putting important information on a Post-it note in a laboratory would really be considered bad procedure. I mean, because any chance that that note could be lost if there's important information on it, I mean, it can have an impact not only on the sample, but potentially on the health of the employees. I just, that's just bad practice.
I would make a motion, unless there's an additional discussion, to accept that there was a violation under paragraph 94 as outlined. And that's so stated on page 23 of the finding as to the NAC 453A 65214, 4, 6, and 7, NAC 453D 7641, 4, 6, and 7, and NAC 453D 9053D and 4. Motion to find a violation.
Ms.
Do we
Member
have a
Young, I'll
second?
second that. Oh,
We have a
yep, I'll
motion, we
second.
have a motion, we have a second. We have any other discussion for the record? No. All in favor, please say aye. Aye.
Aye.
Aye.
Any nays?
Nay.
It carries. Member Durrett dissenting. That moves us to the third category, which is laboratory practices. And under this category, the administrative law judge noted that laboratories are required to test for THC potency, the percentages of THC in the cannabis product, and the pesticides and microtoxins. And their respondent used high performance liquid chromatograms for cannabinoid potency testing. Respondent used ultra performance liquid chromatographs, mass spectrometers to test for pesticides and mycotoxins in cannabis products. The first matter that was up is paragraph 88. The complaint alleged in paragraph 88 that respondent failed to report test results to the department. At the same time, it provided test results to his clients in violation of NAC 453A 6589, NAC 453D .7889. Further, respondent actions in this regard amounted to intentional concealment of those results from the department in violation of NAC 453D .9053A4. To that end, The ALJ found that respondent failed to comply with NAC 453A, 658 sub 9, NAC 453D, .7889. Respondent admitted it provided test results to clients before it issued COAs, and that it did not provide those test results to the department at the time it provided those results to the clients. And the statute talks about electronic information and all information. So further discussion as to this little area.
I have a question. And it is relating to discipline, but I just want to get a little more information to make sure we're not boxed in. I mean, it won't be a recommendation on discipline. And I might need the AG to respond. So this is a category 1 violation. If we found that this violation occurred, what will be our options on discipline? And they're 2 separate considerations. But again, I want to make sure we're not boxed in. Like our decision today won't box us into a specific result.
Well, the regulation does provide you presumed penalties for
Yeah.
different categories of violations.
So what would...
I mean, my understanding is from the chair that you're not categorizing the violations yet, but
Well, if we find the violation, are we finding that it was that category?
We have an option as categories.
Okay.
Look at this.
Okay. Okay.
And I think you have options to find what the hearing officer found or modify it too.
Okay.
Your discretion.
Okay. But then you're saying there's a presumption. What, if anything, can overcome that presumption?
Again, that's your discretion.
That's
These are
discretion.
presumed to be adequate penalties once you get to the penalty phase.
So it's discretionary. There's the presumption, but it's discretionary as to whether we followed those. And we would also take into account the factors listed under 0.9052, like the gravity of the violation, economic benefit, all that. Okay, thank you.
Other questions, other concerns, other viewpoints as to what's involved in this, whether we have a violation or not. If there's no other comments as to this, this is a very interesting and technical area. I went back and forth looking at the wording of the statute itself, what it said, of whether or not early stages of testing could be reported or not reported, or how it had to be. And it makes a of all tests. So if they're reporting the results of a subtest, that's all test. In my reading of this, I would have to agree with the administrative law judge. What it's worth is a different question, but that's where I'm at on that issue. Start the discussion. If that be the case, I would make a motion to accept the hearing officer's findings. um, That it did, that there was a violation of NAC 453D, 9053A and 4 of supplying information of portions of tests only to the clients and did not provide same state as required. That would be my motion. Is there a second?
This is the court reporter, and if you could, Chairman, lean forward onto the microphone. When you lean back, it cuts out. I'm having trouble. And so if you could repeat your motion, I would appreciate it.
If I could repeat the motion, I'd appreciate it too. Anyway, I make a motion for acceptance of the hearing officer's finding there was a violation as provided. And that was pursuant to NAC 453D.0905 sub 3 sub A sub 4. So is there a second on that?
This is Member Young. I'll second that.
We have a motion and a second. Any additional discussion? All in favor of it being a violation, say aye.
Aye.
Aye. Any nays? Any
Nay.
abstentions? Nay from Member Freilich. Okay,
That's
thank you.
Chairman, can I make a comment?
Yes.
Related to what I was stating about the categories? There is the option of finding that a category 5 violation would be anything that doesn't comply with the requirements not described. So I just want to confirm that none of our findings today are related to the category that the ALJ has recommended.
All right. We've been laboring at this a little bit. Let's take a real curt break, 5 minutes, and come back and pick back up on the complaint paragraphs 90, 91, and 92. We are back on the record at this time. We are picking back up on complaint paragraphs 90, 91, and 92, which in the hearing officer's report starts at page 27. The complaint alleged in paragraph 90 that respondent failed to achieve and maintain quality standards of practice and failed to supervise testing staff in violation of NAC 453A, 0.650, 1A and B, NAC 453D, 0.755, 1A and B, and NAC 453D, 905, 3D7 and 8. The complaint alleges that these violations were also noted previously. The complaint alleges in paragraph 91 that respondent failed to adequately train and supervise employees Acevedo, Ruiz, Luling Wang, referred to as Lu Ling in the complaint, and Gail Wang in violation of NAC 453A, 0.6501 A and B, NAC 453A, 0.652, 1, 4, 6, and 7. NAC 453D, 7641, 46, and 7. NAC 453D, 755, 1A and B. NAC 453D, 9053D, 7 and 8. Additionally, the complaint alleges in paragraph 92 that respondent failed to ensure the competency of staff who performed testing of cannabis products in violation of NAC 453A, 0.652 sub 1, sub 4, sub 6, and 7. NAC 453D, 0.7641, 4, 6, and 7. NAC 453D, 0.352, 1, and 3. And NAC 453D, 0.905, 3, D, and 7, and 8. Specifically, the complaint alleges that respondent failed to ensure the competency of Mr. Ruiz by failing to have Mr. Ruiz complete a competency assessment before independently performing cannabinoid potency testing. And over at page beginning at 35, it begins petitioner established that respondent violated NAC 453A, 0.6501 A and B, NAC 453A, 0.652, 1, 4, 6, and 7, NAC 453D, 0.5352, 1, and 3, NAC 453D, 0.755, A and B, NAC 453D, 764, 1, 4, 6, and 7, NAC 453D, 905, 3D, 7, and 8. Respondents' arguments. They were put together because the party felt that they were the same set of facts on this. And if you remember your reading material, this is within this particular count, we have the issue of flasks versus pipettes for testing purposes, among other things. So thoughts, reflections as to these counts.
Member Dret, I probably should have asked this at the beginning, but it's petitioner's burden to establish these violations, correct? And is it clear and convincing?
Clear and convincing.
On the training violations, I don't think the statement it's burdened by clear and convincing evidence. Just to expound a little, I think that the facility gave adequate explanations to some of these. And I think there was some substantiation of these, but not at the level of clear and convincing.
Chair, I just note the regulations for the hearing officer indicate its preponderance of evidence.
Thank you.
Excuse me, whoever just spoke, I don't know who spoke, but also they cut out and I cannot hear what they said. The whole thing cut out.
Sorry, Senior Deputy Attorney Christopher Rath, the standard is preponderance of the evidence as noted by the hearing officer and in the regulations.
This is Member Young. I just, on the board where we see everything, it says that we're currently still in recess. Does that need to be changed?
Yes, it should be changed. We want to be in recess, but we have to come back from the playground. It's nice to know that Dr. Young cracks the whip. Member Durrett, your opening comments were directed as to which one of our 90s.
We're going to take them one at a time.
Well, we have three, even though they're blocked together, we have 90, 91, and 92. So I want to make sure it's exactly where you're at, and if we can deal with that, separate it, and then get to the other ones. So,
Well, similar to the ALJ, I think these paragraphs, she said, the petitioner failed to show that these paragraphs allege 3 different violations. They kind of just run into each other, whether or not there was adequate training and supervision. And I think the what was cited as support for that were potentially issues that occurred that time, but not necessarily repeatedly. So I don't know that there was inadequate training on that. Whether there were mistakes made is different than whether or not there was adequate training. And I think there were adequate explanations for most of those. For example, one where there was a discussion of whether they could use a pipette or a flask, and there was it seemed sufficient, their explanation as to why they used whichever one they did use. I don't think there was an adequate showing that there was inadequate training. I think there was showing that some mistakes were made, but not that the training was inadequate.
I may agree with you as to training being adequate or inadequate or not enough, but then you go to supervision. And in supervision, you have to make sure that your people are doing what they're supposed to be doing pursuant to your SOPs. So if we say that the training was adequate, then the errors are because they were properly supervised to make sure they did what they were, quote, trained to do. That would be my distinction based on what's been offered here. So that goes to competency of staff, 92 and 91. I would probably agree with you then as to 90, as to maintain quality standard practice, fail to supervise testing staff in violation. I guess that would be my compromise of what's there based on what has been provided between pages 27 and 35 of what the conversations and the existence of what happened. Because as an anecdotal situation, all of us know sometimes we're trained, we sit in a room for an hour because we're told we have to go to this training. At the end of the hour, if we're not tested, we walk back out, we sign a slip. It says you've been tested, you've been trained. Do you know what you're doing when you have to do it? Slightly different from what's alleged here, but we have specific situations where kind of the rubber meets the road of seeing whether or not the training that was given was adequate for the party it was given to so they could perform to the standards that are required.
Member Drett, I don't, this is just thinking out loud. I don't feel hard and fast on this position, but my sense is as far as the supervision, if you have some come in for an inspection or an audit and you require this employee to run a test, it's not a measure of how much supervision is going on because you don't know, and I'm not saying they did it incorrectly. I'm just saying you don't know, that's not how you measure how much supervision is going on. I mean, it's the overall operations, and there would be other more accurate ways to assess whether there's adequate supervision. Maybe all of his results were going to get pulled, or maybe they hadn't gotten to the part yet where they covered manual integration. I don't, like I said, this is not a hard and fast position. I just don't think, I think this is such a small window, which I know is a difficulty that we're going to deal with doing inspections and audits, that I don't know that I can assess supervision based on this, which is, again, I don't think anybody did anything wrong here. I just don't think it meets the burden to convince me that that they did not have adequate supervision.
I would respond if it was one lone employee that did not meet their standard, then I couldn't make the jump and say that they weren't properly supervising training. But when the people that were assessed. And again, partially agree with you. You don't know all of it, are found not to be able to do what they are supposed to be able to do, then I have to go to a generalization that these people are at least not properly supervised. Because a supervisor would know if the parties can perform based upon the training they receive. It's a tough one, but that's kind of how we work. And when you have your surrogates, your employees who work for you and do things.
Mr. Chair, this member Merritt,
Yes.
I would like to agree with you. From being in a supervisor's position for many years, and especially in the banking industry, if there are auditors or regulators that is coming in to look at a policy or procedure, and there are several employees that have not been performing that particular policy or that particular procedure, that basically meant, that there is a supervision problem somewhere. And this is kind of how I look at this particular situation.
Thank you. Anyone else want to raise a thought one way or the other? I would make a motion, and if the motion is too convoluted, it can be broken up, to not find a violation as to paragraph 90, but to find violations as to paragraphs 91 and 92. And 90 is as to maintaining quality standards, practice, and supervised testing, staffing. However, 91 and 92, that's to adequately train and supervise. 92 is failed to ensure competency of staff who perform testing. So going with that distinction, that's my motion. If it's too convoluted, there would be no second. If we have a second, we can move forward with a vote.
This is Member Young. I can support that, and I will second the motion.
We have a second to the motion. We have an additional discussion. All right. All in favor of that, of finding no violation as to paragraph 90, finding violations as to 1 and 92, please say aye.
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 Those who wish to say nay.
Aye.
Carries unanimously. That would move us to complaint paragraph number 93. Paragraph 93, the respondent failed to analyze THC potency in accord with its written procedure and in a way which would ensure accurate reporting of Delta 8 THC and cannabinoid CBD, cannabidolic acid CBDA and CBN in violation of NRS 453A.3682A1, NAC 453A.65441A, NAC 453D.7821A, and NAC 453D 9.9053D7 and 8. And the hearing officer noted petitioner established that respondent failed to comply with NRS 453.3682A1, 453A.65441A, NAC 453D.782 NAC 453D.9053D 7 and 8. In this case, and this was as to testing policies. And this is really was the looking at the instrumentality that was being used, how it was being operated, lack of manual integration. And as testing came, whether you had spikes or didn't have spikes, kind of the anomaly of testing when you had different results. So a problem with the machine during the testing. That's what this particular paragraph was.
This is Member Young, just more of a comment. I think this particular violation just reflects back on the previous violation, the inadequate training and supervision that occurred.
Member Drat, I agree. That's was my sentiment as well, that what it's charged under is disorderly activity. I don't think that is related to disorderly activity. What would be more appropriate is if, you know, there could be a disagreement about whether this was appropriate or not. If there is one, it would be as to training and supervision. So I wouldn't support this finding a violation here.
Unless someone wants to weigh in, I would make a motion for finding there was the violation as outlined by the hearing officer on page 40, failed to comply with NRS 453A.3682A and 1, NAC 453A.6541 sub A, small a, NAC 453D 7821 small a, and NAC 453D 9053 sub small d 7 and 8. That would be the motion. Is there a second?
This is Member Young, I'll second that.
We have a motion and a second for accepting the report of violation. All in favor, please say aye.
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 Aye. Nay.
And we have one nay. Member Durrett, motion carries. That takes us to complaint paragraphs 95 and 101. And the complaint alleged in paragraph 95 that respondent utilized an unsanitary homogenization method that allowed cross-contamination of test samples in violations of NAC 453A 6521 4, 6, and 7, NAC 453D 76.7641 4, 6, and 7, and NAC 453D .905 3D 7 and 8. And as to paragraph number 101, respondent utilize the chemistry samples, chem samples, to retest products which initially failed microbiological testing in violation of NAC 453D 7641, 4, 6, and 7, and NAC 453D 9053D 7 and 8. And to that end, the hearing officer found that respondent failed to comply with NAC 453.6521, 4, 6, and 7, NAC 453D 7641, 4, 6, and 7, NAC 453D 905, 3D 7 and 8. The hearing officer made a kind of the finding again of finding that there was a violation, but based upon all the information provided, thought that we should only find one violation to. And he noted that the party depleted the microbiology portion of the sample it used. It used the chemistry portion of the sample to complete microbiological testing, and admitted it used chem samples for microbiology testing, even though it knew that the chem samples treated in a less aseptic manner than the microbiology portions of the sample, and consequently would be contaminated with microbiomes. Admitted that he used harsh solvents in the cleaning of the gloves and other material. Comments. Again, I look to you, Dr. Young, as to this area.
Again, this comes back to poor lab practices, which could significantly affect the results of the laboratory, both in a positive and negative for the person providing the sample. Could potentially sterilize the sample so that there would be no microbial testing, or if you dilute it out, that microbial testing would be inadequate. But likewise, you could accidentally introduce microbial or other contaminants and change the outcome. I mean, ultimately, from looking at this, for me, I think this is just, again, just another example of poor lab practices.
Unless someone else wishes to weigh in. Would have a motion to find violations as to both 95 and 101 in accordance with the findings of the hearing officer, noting as we get to the next phase, we should constitute a single violation out of the two.
I have a question.
Mr. Chairman, I just wanted some clarification about those two, but I can wait.
Please say again.
I just wanted some clarification with regard to paragraphs 95
and 101. It's my understanding that the hearing officer found a violation for 101, but not 95. Is that correct? Is that what the motion is, or was your motion?
Well, the motion was, it could be reworded that way, but he found 2 violations, but his position, and I would support that, we should only look in terms of penalty as 1 violation for the 2.
Would you accept a friendly amendment to
Yes, I
have,
would.
okay, to find in violation of 1 violation of paragraph 101? In other words, to agree with the hearing officer's recommendations to find none for paragraph 95, find 1 violation of paragraph 101.
I would accept that. Do we have a second?
Member Merritt, second.
We have a motion and a second. In essence, the motion on the floor is to find no violation as to paragraph 95, but a violation as to 1. Member Durrett?
I have a question. In finding the violations, are we substantiating not the category, because we decided that will come later, but the code that it's cited under? So for 101, the cited code is disorderly activity. So by finding the violation, are we substantiating that there was disorderly activity, or are we saying potentially that this was a violation of good lab practices?
Okay, let's go back. You're saying that you have a disorderly practice under 453 D764, one of the subs, or NRS NAC 453 D905 3D7 and 8?
Correct. So
should we eliminate one of them or both of them as to violations?
So the first 3 NAC that are cited, like 0.652, 0.764, first 2. Okay. Those are mainly how labs operate and what publications they have to follow. Are we finding that it is a violation subject to discipline for not following the publications referenced under the first 2 NAC, or are we finding that it's a violation of section 3D7 disorderly activity? I don't know if you can have a violation of any statutes outside of, or any NAC outside of 0.905, but I don't know. So I'm asking, what are we finding that was violated? And this matters to me because my position and argument is it's not necessarily actionable to violate the good lab practices because we haven't really delineated or made clear which part of those publications are actionable violations. So it would need to come under 0.905, and I think the disorderly activity is not related to what we're dealing with. Disorderly activity is obviously for noise violations. It's not a catch-all for anything that violates the regulations. So it's purely technical because I think that this homogenation process was not correct because they used the chem samples for microbials and there could have been contamination, but I don't know that that violates.
So you would reverse it and find a violation in 95, not 1.
I don't.
Let me look at 95.
Because 95 is specifically the cross-contamination and sanitary.
Well, no, it's a similar issue. Is that what's cited is either disorderly activity, and I don't think this is this conduct relates to what was meant by disorderly activity.
Well, if you use disorderly context more specifically in the scientific term, then it fits. If you're thinking of it disorderly conduct in another phase, no, it wouldn't fit. But disorderly conduct would have to be related to the field that we're working in, and working in the conduct of not following your SOPs or things of that nature. So that would be your disorderly conduct.
So it's kind of like a lay interpretation of disorderly, just the plain meaning of disorderly. So the finding is that there was a violation under 0.905, not necessarily the other NAC. I mean, those are just.
I can live with that. If that's.
And Chair Douglas, just for purposes of the record, that's just you clarifying your motion.
At this point, I'm trying to see if I have, if that's, Member Durrett is comfortable with that.
Okay.
Before we try to clarify.
I think I have to be consistent with my other votes in that I don't think disorderly activity, I view it as noise complaints, something like that, noise complaints. So I think I have to be consistent.
I think we had trying to trace my steps backwards as to where we were. We accepted friendly motion, we had a sec. We had 4 voting for, and then we had 1 that was an A.
I don't think you've taken the vote yet.
That's why I'm asking.
No, we only had a motion, but we haven't reached a second yet.
Yeah, friendly motion. Member Freilich to find 1 violation, specific violation, accepting her amendment to find a violation of reference 101. We know that we had in the discussion period that we should not find under the secondary part.
Ms. Member Young, can I make a comment and possibly ask a question?
Yes, sir.
In regards to paragraph 95, there's 453A and 453A 652 and 453B 764, which those, in regards to lab practices. I mean, I think they clearly violated those. And then in question to 0.95, I agree. I think 7 is a little disorderly activity, but 8 specifically doesn't say, which violates the laws of the state. And if you have violated 453A, 453B, 746, haven't you then violated the laws of the state? So then that applies to you. I agree about the disorderly conduct. I mean, I don't think they're running around screaming, yelling, but they are participating in an activity which does violate the laws of the state in regards to law practices or lab practices.
Can I, Member Drat? So this is the discussion that I want to get at, and because I don't know where we're at on it. And well, I do have a position that we haven't fully developed. Okay, this is what our regulations require. They refer to these voluminous texts, and not everything in those texts is currently in practice in the industry. So how does the industry know what in those texts is going to lead to discipline or not? And I think we have to have that discussion. And until we have a discussion about, okay, we've referenced these publications, but we don't really expect every single word of every one of those publications to be in practice. And so how does the industry know when diverging from that practice is going to lead to discipline? I think we need to put some parameters around that.
I guess to respond to that indirectly, the officer noted, like at one point, responded did not provide an SOP to the department for sample preparation and homogenization process used by Mr. Wang, but respondent did not dispute that Mr. Wang used respondent's method to prepare the homogenation and chem samples. And then we get in the argument about sanitary, not sanitary. But what is clear, as was talked about, was we have, by doing it the way it was done, it led to the ability for the chemistry portion of the sample to test the potency, moisture, heavy metals, pesticides, solvents, terpenes, foreign matter pose a contamination risk for those tests. How much leeway do you give? I guess it's the question. You have your SOP, again, have SOPs. They're not worth anything unless you follow even your own internal materials. We talk about the testing, we talk about gloves, disposable gloves that were not necessarily disposed of on each test. They were supposedly semi-cleaned with solvent that created a problem. As was talked about, we have a situation where if we're going to have clean test and proper testing, certain things have to be followed. And some of it, I'm sorry, are so simple that it's not something that takes a lot of deep thought. They should know better. And know better because they have SOPs. And they know better because they've been trained. And you can't keep just letting them off the hook because an employee refuses to follow training, which means they're refusing to follow supervision and they're not supervised. Or take the other way, it's allowable practice at that particular laboratory, and the laboratory should be held accountable. But either way, you're not doing what you're supposed to do. Could be a myriad of reasons, and I'm not assessing one reason over another as this particular facility, but it shows there's a it creates a problem for someone who's supposed to do testing and is supposed to be the gatekeeper of public safety and the safety of the product. So again, we're still trying to play with, I know our attorney is concerned. We're still trying to craft this motion so we get a clarity as to what we're doing. So I appreciate the discussion and trying to find something that we feel comfortable finding. And Dr. Young, I'm going to put you on the spot. You may not want to be on the spot. We have two counts, 95 and 101. If we were to eliminate one of the counts based upon what's being offered here, since the hearing officer said there were two violations, but we should only charge one, which one would you be more comfortable as the cross-contamination or the chem sample issue? So that's 95 or 101.
Yeah, that's a fair question. I mean, I feel that they're both in violation, although they're somewhat related to each other. But between the two, I think paragraph 101 is the one that's the clear violation to.
And coming all the way around, then I think Member Freilich, in our discussion, your position was for us to find a non-violation of 95, but go with 101. And correct me if I'm wrong.
Yes, that was my proposal.
Okay. Okay. Then the motion that I made as to finding non-violation as a 95, but a violation as to 101 is the motion I would present. The question, is there a second?
This is Member Young. I'll second that.
It's been moved and seconded. Discussion, and Member Durrett, if you wish to restate the position for the record.
Yeah, I agree with the other members that this could have led to cross contamination, and then the chem sample would have been used there's an admission that they would use that for microbials. But I'm going to vote nay solely because I think there needs to be more guidance on what practices are going to lead to violations.
Thank you. Anyone else? With that being said, all in favor of the motion for non-violation of 95 and violation as to 101 according to the record that we have before us and the statements made provided by the hearing officer, please say aye.
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 Aye. Aye. And any opposition opposed, nay?
Nay.
Member Durrett was a nay. Thank you. Motion carries. That now takes us to paragraph number 97. The complaint alleged in paragraph 97 that respondents' pesticides and mycotoxin testing procedures preclude accurate reporting and endanger the public in violation of NRS 453A, 3682, small a, 2 and 4, NAC 453D, 0.905, sub 3, sub small d, 7 and 8. Specifically, the complaint alleges that respondent continued to report testing results following quality control failures and before taking corrective actions to identify and resolve the issue which led to those failures. And to that end, respondent failed to comply with NRS 453A.3682, A2, and 4, NAC 453D, 0.905, 3, small d, 7 and 8. Respondents basically the testimony offered by respondent employees regarding CCV failures and corrective actions were not satisfactory substitutes for actual documentation, failed to adequately explain why numerous CCV failures in December of 2019 were merely monitored, and corrective action was not taken to ensure that respondents' pesticide test results fell within the tolerance range respondent established. And finally, respondent failed to follow Nevada law and its own SOPs. It was a position taken by the hearing officer after hearing all the information and is adequate as to the record that was put before us. So the question is whether we agree or disagree. And it's a very technical issue, noting that at some points when testing, if results fell outside those tolerance limits, they should have been required to stop testing with a particular instrument and determine why the results fell outside the tolerance limits, resolve the issue before placing the instrument back into service, and document this process. And again, noting that their own SOPs, titled Quality Manual, recognize these responsibilities and included provisions for ensuring validity of results in instrumentation instructions for non-conforming work procedure. And there's another note as to the SOPs that the officer found. Discussion as to this.
Member Dredd, actually, I'm sorry. Am I looking? This is 97, right?
Yes.
Okay. Similarly, so I won't go into too much detail. Again, this could be a problem. I don't know how big of a problem it is. It doesn't necessarily lead to false results that are, making people sick. I don't want to say the standard is whether or not somebody actually got sick, but I don't know that the testing wasn't actually, the results weren't accurate. This is more about the process of getting those results. And I want there to be more discussion on which portions of lab practice publications are actionable violations. So similar to the previous ones.
I understand your reliance, but again, when they have their own standard operating procedures, they don't follow them. There's a note that the hearing officer noted as to following their own procedures, maintenance logs for the mass spec. Logs showed the instruments were not serviced or maintained in December 20, despite the numerous quality QC failures and respondents' determination as recorded in its corrective action log, and the UPLC was not performing ionization properly. The publications that sometimes are the Mount Everest of. If you come down and you set your own standards, you at least have an obligation to follow those. If you don't follow those, what are you following? That's in a nutshell what's been derived and presented to us here as to having.
Commissioner or Chairman, the
I'm sorry. I'm sorry. I would make a motion that the evidence is sufficient for the violation. In this case, as to paragraph 97, precluded accurate reporting and endangered public in violation of NRS 453A, 368, 2A and 2 and 4, NAC 453, 905, 3D, 7 and 8. That would be the motion. Fail to comply.
Is Member Young? I'll second that.
Been moved and seconded as a violation. We have a motion. We have a second. All in favor, please say aye.
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 Nays?
Nay.
Read as a nay. That moves us to area number 4, retesting. Complaint paragraphs 98 and 102. In this, again, the complaint alleged in paragraph 98, respondent performed unauthorized retesting of samples for microbials in violation of NAC 453A.658.11, NAC 453A.672, 3, 4, 5, and 6, NAC 453D.788.11, NAC 453D 7903456, NAC 435, D 9053A3. Noting that the complaint alleged that when respondent reported passing microbial results to the department following the retesting, it falsely reported passing results because the initial test result showed that the sample failed microbial testing. In complaint, they allege in paragraph 102, the respondent falsely reported 43 aspergillus testing results as passing when the sample in question failed initial microbial testing for that antolite. in violation of NAC 453D.9053A3. And the complaint further alleges respondent intentionally misled investigator. But that's what has been offered. And to those two items, petitioner established that the respondent failed to comply with NAC 453A.658, NAC 453A 6723, 4, 5, and 6, NAC 453D.78811, NAC 453D.79003, 4, 5, and 6, and NAC 453D.9053A3. Respondent failed to present evidence. I won't. Anyway, the hearing officer has the both of those 98 and 102. Again, we need to find a single violation for both of those counts.
Mr. Chairman, I'll make a motion
Yes, please.
that we agree with the hearing officer's decision to find one category 2 violation for paragraphs 98 and 102.
If I would ask that we just have a violation and not deal with category at this time.
I'll rephrase.
As to 98. Okay.
That we've that we find a violation of paragraph 1 violation of paragraph 98 and 102 as recommended by the hearing officer.
Okay, can I ask that you then restate a friendly motion that we find that there's a violation as to paragraphs 98 and 102 and we accept the hearing officer's recommendation based on the evidence presented. There should be only a violation or a penalty considered for one violation.
And I'll have that be my motion. Thank you.
I would second. Any discussion? Further discussion? All in favor of the motions, please say aye.
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 Any nays? We carry unanimously.
Hopefully I wouldn't say that on all of them.
I know if we don't feed you, we'll get you to agree. That takes us to item number, paragraph 99. Alleged paragraph 99 that respondent performed unauthorized retesting of samples for heavy metals in violation of NAC 453D, 0.78811, NAC 453D, 0.7903, 4, 5, and 6, and NAC 435D, 9053A3. Complaint specifically alleged that when respondent reported passing cadmium results for test performed for silver sage wellness cultivation to the department following the retesting, it falsely reported passing results because the other test results for the samples showed the samples failed heavy metal testing for cadmium. And at the end of that, on 59, petitioner established that respondent failed to comply with NAC 453D 78811, NAC 453D 790-3, 4, 5, and 6, NAC 453D 9053A3. And there's other language there, but that's the sum of what we have. And you have the discussion in between. And that was the issue of the testing and whether or not they as part of the procedure, tested through 3 times to get 2 positives or 2 negatives. Usually it was a failure the first test, supposed to test 2 times thereafter if they got a positive. And so the allegations or discussion was if they fail and got a positive, had a negative test and a positive test, they report it positive rather than take the 3rd test to make sure that one of the prior tests were correct. That kind of the substance of get into in that count.
Member Draft, for the record, I have a question. The alleged violation is not for charting the results, right? It's for retesting without reporting. Okay, thanks.
Yes.
This is Member Young. I'm ready to make a motion in regards to paragraph 99 that approve the violation set forth by the officer.
We have a motion to approve the violation as so set forth by Member Young. Do we have a second?
Member Merritt, second.
A motion, we have a second. Any additional discussion? If not, all in favor, please say aye.
Aye.
Aye. Any opposed? That last one was 99. We are now at 100. Paragraph 100, the respondent performed unauthorized retesting for samples for cannabinoid potency in violation of NAC 453D.782, NAC 453D.790, 3 and 4, 5 and 6, NAC 453D 9053A3. The complaint specifically alleges that when respondent reported higher cannabinoid potency results to the department following the retesting, it falsely inflated THC potency, which was a deceptive trade practice. And to that end, at page 66, petitioner established respondent failed to comply with NAC 453D.782, NAC 453D.790, sub 3, 4, 5, and 6, and NAC 435D.9053A3. And alluded to using retesting in an attempt to control its cannabinoid potency test results and avoid reporting lower test reports to the department. That he failed to follow Nevada law when it engaged in these practices. Comments, discussions, concerns.
Member Dret, we're on, okay, is it 90?
100 at page 15.
Oh, we're not on 96? Okay. Okay, thank you. Chair, are you ready for a motion?
Yes.
Member Dret, for the record, similar to the other retesting violations, I move to find that there was a violation under paragraph 96. I'm sorry, 100. 100.
We have a motion. It comports with the
Second that.
violation.
This is Member Young.
Okay, thank you, Member Young. All in favor, please say aye.
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 Aye. Ayes. Carries unanimously. That now gets us to number 96, which is Area 5, Quality Assurance and Quality Control Program. The complaint alleged in paragraph 96 that respondent failed to maintain a quality assurance and quality control program in violation of NAC 453A, 0.652, 4, 6, and 7, NAC 453D, 0.405, NAC 453D, 0.7641, 4 and 6 and 7, and NAC 453D, 0.905, 3D, 7, and 8. Petitioner specifically alleged respondent engaged in 6 practices which show that it was not adhering to quality assurance and quality control programs. And to that end, over at page 71, petitioner established that respondent failed to comply with NAC 453A, 652, 146, and 7, NAC 453D, 405, NAC 453D, 764, 1, 4, 6, and 7, and NAC 453D, 0.905, 3D, 7, and 8 by failing to maintain a quality assurance and quality control program.
Member Dret, for the record, I didn't go back to cross-reference if each of these was a separate violation. Do you happen to know is each of these a separate violation as well?
You say separate violation.
Like using the flask instead of the pipette is already covered.
This would be a single violation. Those were instances that substantiate
The exceeding tolerance limits, we covered that. The HPLC data and the integration, we covered that. Yeah, she cites the other paragraphs where all of this was covered. So it's not a new violation, it's just a different category.
that would be correct.
Mr. Chair, can I follow up on that?
Yes.
Would it be possible to just take a few minutes because since we've voted on some of these items, I want to just make notes to myself on the margins as to how we held, just for consistency, so that I'm not doing something that's inconsistent with my vote on the prior items.
I don't have a problem with going off the record for about 5 minutes or so, so folks can gather their thoughts and make sure they're doing what they think is correct. Take a 5-minute break.
Thank you.
Excuse me, I cannot hear anything.
You couldn't hear me because my mic was off. I think my mind is off too, but that's probably something that's been going on for a while. We're back on the record with Quality Assurance and Control Program complaint paragraph number 96. For the record, I would vote to approve this violation. However, in that, I would not adopt the third portion in the hearing officer's findings and recommendation. That is the instrumentate in terms of the flasks and in the potency testing, because that's where, as a group, we kind of disagreed with that as an example. But as to the first and second and fourth comment by the hearing officer and the fifth comment, I would adopt those. That's my thoughts on it. So the question is other members' thoughts. Since we're just talking.
Member Durrett, for the record, since these have already been covered by other allegations, I wouldn't support this. I don't think that, I don't like the approach of, I think that's similar to stacking, finding different ways to name the same violations. You see that in criminal. This isn't criminal, it's administrative. We want to fix the problems and move on. So I don't like the approach of pursuing the same violations under different names.
Mr. Chairman.
Yes.
And I would echo that sentiment. I feel that we have found violations under separate categories. I think that the underlying message is that, perhaps there are violations of quality assurance and quality control program, just by the mere fact that we found violations on those examples. So I would not be able to support a finding of a violation for this item number 96.
I, for one, just being on the opposite side of it, would agree and disagree all at the same time. They are violations that have been covered previously. However, they come under a different category. I think you may refer to them as stacking, but the reality is looking at the totality of what occurred as it affects other areas and where you level the playing field, so to speak, is how you assess your final determination as to what should be done about it. You don't look the other way and say, well, that area is not violated. You look at the area and say, yeah, we had violations. They also came in this area. But if you're rational about it, you say they're duplicative and you scale whatever you're doing on the punitive end, so to speak, accordingly. But I wouldn't take a blind eye and say, oh, gee, this didn't happen. Part of the reason for doing duplicative, as you're saying, charges is that you have courts later, and even in courts that are going to review, they might uphold it one way and not the other. So that's the rationale sometimes why you have duplicative charges. You're not necessarily insanity looking for duplicative punishment, but you want to make sure if you think there's an issue, that issue stays and doesn't get dismissed. If you only go to one violation.
This is Member Young. I had one, I guess, question. In terms of one of the violations, NAC 453D 405, that appears to be for requirements for dual licensure, and I'm not sure how that applies here. And maybe I'm reading this incorrectly.
No, you probably caught something very good. That was 453D 405. Any other thoughts or finding things that should be there? I'm going to make a motion. And as Dr. Young has said, for finding a violation as the complaint paragraph 96, violation of NAC 453A 652 1, 4, 6, and 7, striking NAC 453D.405. We continue with NAC 453D.7641, 4, 6, and 7, and NAC 453.9053D, 7, and 8, and ask that within that people remember where you have cross violations on the backside when you determine what should be done about the violation. Not that there was not a violation, but what should be done, and separate the two issues. So that would be my basic motion, is to accept less the 453D 405 on the floor. I don't know if I'll get a second, but that's my motion.
This is Member Young. I'll second that.
All right. We have a motion. We have a second. Additional discussion. Then all in favor of the motion, please say aye.
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 Nay.
Any nays?
Nay.
Member Frederick, were you aye or nay?
I was a nay. A nay.
Eight passes 3-2. That brings us to item 1, paragraph 103 under Roman numeral 6, impartiality. And the respondent failed to maintain impartiality in testing practices in violations of NAC 453A.652, 1, 4, 6, and 7, NAC 453D.764, 1, 4, 6, and 7, NAC 453D.9053A3, specifically alleges that for 5 of his clients responded inflated potency test results, past microbial failures, past heavy metal failures, and test flour as trim. And these practices were for the benefits of respondents' clients rather than yield accurate testing results. After the discussion, making points of where the hearing officer saw that, they recommend that we find these violations as separate violations, but find a single category 2 violation. This is a very interesting issue. I'm, for one, if I'm going to find a violation, I would find a single violation for all those things alleged, not multiple violations, just for starts. I'd like to hear other members weigh in on as to violation. So,
Member Drett, for the record, similar to the last violation, we've already dealt with these violations. Now we're just like naming them other things. I don't think impartiality is the violation. I think the violation is the retesting without providing the COAs to the CCB, retesting after getting negatives, but not retesting after positives, et cetera. So I think this conduct occurred, and I understand that maybe that's a discipline issue, but I wouldn't want to find additional categories if it's repetitive. So I wouldn't support this.
any other member wish to weigh in? Mr. White, would you like to make a motion?
Sure. Member Durrett, I move to decline to find a violation relating to paragraph 103.
Ms. Member Young, I'll second that.
We have a motion and we have a second. Any discussion? All those in favor, please say
Aye.
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 I would be the nay. Passes 4-1. That would conclude this portion. For the record, I know that our usual time for a transcript or whatever is about 3 weeks. If we can get a transcript, because I know there's another version of this transcript, I'd like to have the discussion as to categories and ultimate determination of whatever I use a general term, sanctions, not correctly, but what the board's going to do with this now that they found what they found. And at that time, as we go through that, the proponents will make argument to the board as to violations and how they should be handled, because we'll do that separately. So we will set that for the end of our next meeting in 1 month. And that's if, in fact, we can get our transcript within 3 weeks. With that, as much as I hate to say it, the only thing we have left is our second opening of a public hearing for the public to make comment. Public comment we're obligated to make.
Yeah.
And that's, I covered future agendas prior. Ms. Maxim.
Thank you. For the record, I'm Kimberly Maxim Rushton, appearing on behalf of Let Us Test. I actually had some clarifications, Chair Douglas, with respect to the next proceeding. Will there be an order issued that specifically identifies the violations you found and what they line up to in terms of the specific regulations? And let me give you an example, because I'm just asking for clarification on item 88. It was specifically stated that it was a violation of NAC 453D 905. That's a category. That's not an otherwise regulation in which there would be a violation. So, and I don't recall actually there being a vote on that, but that could just be my misunderstanding. But I think it would help the parties if we could get a specific order that identifies the complaint violation and then what it lines up to in the regulations so that we can properly prepare. That's acceptable. The other thing is that if this is going to be considered at the next agenda, I will not be present. I'm out of the country speaking at a gaming summit in Ireland, and I can't change my plans. So I'm just simply noting that for the record and asking for an accommodation if possible.
Only if you can take us.
I could respond briefly, Chair. I think we'll have the transcript, so we'll know what the rulings were, and I think it'd be appropriate to have one order finally at the end of everything. And I have no opposition to continuing the second portion to July to accommodate Ms. Rushton.
We, in light of your schedule, will not do that.
Thank you.
In light of your other requests, we'll do an order because it helps us as well. So thank you.
Yes, sir.
We have to make sense of this. If we're going to continue this, we will then contact both sides for a date. We will not want to do it necessarily at the back end of a meeting because it's going to take time to hear the position of both parties.
Sir.
So as to say we're rushing through whatever, because I know we'll have good counsel as to what we should or shouldn't do and why. So
thank you for
yes,
the
I'll accept
accommodation. I appreciate it. Thank you.
public comment.
Good afternoon, Chair Douglas and distinguished members. For the record, speaking, my name is Timothy Eliado, representing Coral Lounge. I came during the first portion of the public comment. My name was mentioned, so I came to clear the air. I would like for the board to understand that I had previously in the past made specific allegations to the board. I stand by those allegations. And once again, I am aware of the legal ramifications and every word that I say in this process. It all began with consumption lounge bill, in which 3 specific or 4 players were involved. I would have to state, for the record, now Commissioner Richard Tig Sagerbloom. Then we had Scott Rodledge. And for the record, again, Steve Yeager, all being a part of the problem. And this is what I mean by the problem. Mr. Tyler, member Reina, also part of the problem. Why do I say this? Well, it's an organized that has been part of this system for quite some time. And we've been through the Department of Taxation with its issues and corruption. Steve Sisolak, we had gained international coverage about this specific corruption issues here. Well, Governor Steve Sisolak at that time initiated the CCB as a means to mitigate the problems that we had within the corruption issues that had arisen. Okay. Well, there was a solution, and the solution was quite simple. Create a social equity program with no foundation. Find individuals in the community that had no experience or expertise in the cannabis industry. Place them in authoritative positions. They get to make the rules and they get to reap the benefits. Okay, let me begin.
Sir, I'll give you 2 minutes.
Okay,
You get to wrap it up.
thank you. Example, one of the most popular cultivation facilities we have here currently, Green Life Productions. A friend of mine just sent me a post they made I'm not sure exactly when, but it just states that they are working on finding specific cultivars or chemovars with, you know, THCV properties. So I wanted to show the board that this is a COA from 2016. I had accomplished that goal, 2016. I'm ready to show this to the board. It's right here. Okay. When we're talking about expertise in this industry, what is the level of expertise that Aisha Goins possess? What is Aisha Goins accomplished in this industry? What has Shelly and Chandler achieved in this industry before they were placed in the position in which they now have licenses? They stood here in front of the board. Chandler specifically, he instructed the board. He had, on behalf of CEIC, submitted applications for social equity applicants. Not once did Chandler indicate that he himself is an applicant. This is a very serious issue. It's currently in hand, and I spoke to the governor's office, Sonia representative, who had stated that there's currently a Senate bill in place that could hopefully put a stop to this. Because as of now, yes, the CCB does act as its own sovereign agency without any legislative oversight or very little legislative oversight. You have achieved what you're accomplished to do, which was create a codependency, social equity. You achieved it because those that received it are asking for funds. They have very little expertise in this industry. And because of that, they're always going to be dependent on Tyler's friends, Senator Tick,
I'm going
Commissioner Tick Bloom.
to cut you off at this point. I gave you time. You have anything else, put it in writing and submit it to us. Just leave it right there. We have anybody else for the public record?
Oh, I'm sorry, once more. This is Sunflower Compassionate Company owner, Shelley, right in place. CCB issued her a license in which her company was expired at that time the license was issued.
You made your point. We were given out.
Thank you.
So.
Thank you, Rachel Lee, Sunflower Compassionate Company, for the record. Okay, just for the record, my experience in cannabis has nothing to do really with the professional level, but it does have everything to do with the personal level, being that CBD has changed my mother's life, who has been diagnosed with Alzheimer's disease for over 12 years. And also for the record, when these establishments became into place, no one had the experience or the expertise in how to do any of these establishments. So if the problem was if a person was qualified for social equity, the definition of social equity is someone that was pretty much disenfranchised or held back from laws, a person that was adversely affected by the previous laws. And that happened to me in '94, but today I still don't have a relationship with my children because of that law that changed my life. Second of all, had you been in a position where you was approved, you would not be here complaining. I have never seen you on E Street, H Street, Mario's West Side Market, so you're not social equity. So what? find another way to get into the industry if the medicinal side of it is really important. But coming up in here trying to bring someone else down that has attempt to find a way to change other people's lives is unnecessary. I don't know these people. Never met them in my life. And as a matter of fact, they didn't come find me. I went looking to find out if there was a possibility that if I was breaking a law by making a product for my mother. I came in here when this setup wasn't even here. And there was a table where Aisha was and the committee was talking about the program. So stop spreading stuff that you do not know. I don't know them. But what I wanted to say, if I have a little bit more time, if I had 200K, I would more than likely not be considered as a social equity applicant. So I really did want to know the definition of assets. And also, I did not see anywhere in the jurisdictions or the regulation, I'm sorry, in the regulations that state that once a location was approved, as far as the jurisdiction, that I was not able to move. And the concern for me on my behalf is that if I don't find a location based on the fact that a lot of these commercial companies or realtors do not want either the establishment or they're not willing to rent to a cannabis industry applicant, then that puts me at a place where I won't find a location. And I do have a letter from a gentleman that is in a separate jurisdiction that is willing to rent to me a location for this particular use. I do apologize about getting upset, but this is a repeated situation where someone's not only putting someone else's name, because I don't know the man, I don't know his friends, and I'm not trying to be funny, don't care to know your friends. But then if you're talking about something that he's doing corruptive, then that means you're saying that I'm corrupt too. No, you don't know me. And I'm not going to waste my time spending my time here with you on stuff that you don't know. But what is corruptive is a man that was trying to convince someone who didn't know anything about this situation to let him pay $2,500 just so he can gain 49% ownership. Now that's corruptive. Thank you.
As to your point, anyone else anyone else wish to public comment, either north or south? Then we'll close the comment. Just a quick comment back to you as to your point. If you have questions about what you can and can't do, it needs to be submitted to the department in writing so they can respond to you and respond to everyone else's simulated. That's a policy we got into, so it's no favoritism in terms of information provided. So your address as to assets or other thing, put in writing, give it to the department so they can respond and put it on the board. With that, we are adjourned.